would everyone ensure that all electronic devices are turned off or switched to silent? Tea and coffee are not permitted in the committee room. We're continuing line by line of the terminally ill adults end-of-life bill. I would please remind members that intervention should be short and raise points of clarification or questions. They should not be speeches. Members who do wish to give a speech should bob and to continue to do so throughout the debate in which they wish to take part in until they are called. And can I also say, when members say you, they are referring to the chair. You should not be used to refer to each other throughout the debate. We will continue with Nal Shah to continue her speech. Nal Shah.
Thank you, Chair. It's a pleasure to serve under your chairmanship, albeit it might be the last time for the Skills Committee. I was speaking to new clause 36 and 37, and if I can just repeat the last paragraph just to bring myself up to speed. If that interpretation is correct, surely we could have tighter wording, and the new clause could say, for example, the Secretary of State decided to allow private firms to provide assisted dying to paying customers. Then the Secretary of State must make regulations to govern that. I would welcome any clarification at the point if the sponsoring member of the bill would be minded to accept that amendment, given she's accepted the amendment from may to must in other amendments, but I'll happily wait for her when she concludes her remarks. Finally, we come to what I think is the most important part of this new clause, the powers under subsection 1 to commission assisted dying services. How the Secretary of State uses these powers will be crucial to the system's transparency and to the impact of assisted dying on the NHS. We do not know if the Health Secretary will contract private firms to provide services to the NHS, or if he will, or if all assisted dying will be provided under the NHS. We do know that many parts of the medical profession are very strongly alarmed by the idea that the NHS would provide assisted dying. For example, the Royal College of GPs said this in written evidence, that's TIAB 108. Its evidence said, and I quote, "The Royal College of General Practitioners does not believe that if assisted dying is legalised, the process should be integrated into existing care pathways as part of the standard care and treatment they provide, i.e. assisted dying should not be deemed core GP work." It went on, "As such, we consider that if assisted dying is legalised, the bill should make provision to establish a separate assisted dying service. This may help ensure that assisted dying was not a core part of GP work, and that any doctor who did not want to be involved would not be forced to do so." So there is a problem here. Given the Health Secretary the power to commission private firms to work as contractors to provide assisted dying would perhaps solve that problem. Now, there are skilled healthcare professionals working in this private sector. The Health Secretary said in an interview with The Guardian on the 10th of January this year, "Where there is spare capacity in the independent sector, we will use it. We have agreed that we will work with them and they will work with us to cut NHS waiting times." But the Health Secretary added, "At the same time, the independent sector has to pull its weight. It's got to be genuinely additional capacity." I'm entirely pragmatic about this. I agree entirely with the words of my honourable friend, the Health Secretary. Where there is genuine capacity in the private sector to help the NHS complete its task, of course we should use it. But it's not only private sector healthcare firms which are likely to bid for any future assisted dying contract. There are other firms which have a good chance of winning those contracts that we should be very concerned about. The Minister has made it clear that the Government is considering using private firms for assisted dying. He gave an important interview on assisted dying with Politics Home, published on the 11th of March. The Minister said that the member for Spen Valley, and I quote his words, has said that she wants this service to be an integral part of the NHS, meaning free at the point of use. Certainly, the advice that we as ministers have given her is we've clearly understood that that is her wish, and that is a wish that can be delivered and carried out. The Minister continued, "Now, free at point of use doesn't preclude the use of independent contractors to deliver the service, so yeah, we're comfortable with that." Unfortunately, we have seen major failings in the way private firms handle important contracts given to them by the Government. These have happened under all three major parties in England and Wales. I want to quote from an excellent book by Sam Friedman called Failed State. It's not some foreign country, but about our own. I should say that Sam Friedman was a special advisor of the Conservative government working for Michael Gove, so I don't think he's someone on the far left. Chapter 3 of his book concerns outsourcing. Its title is Contract Killings. He says about outsourcing contracts that they can work well if the three conditions are met. There need to be many firms or public organisations competing to offer a service. The regulator needs to be able to clearly measure whether or not the firms have delivered this service to a good standard. And finally, he says government needs to be able to hand over most of the risk of failure. If the taxpayer is still on the hook for picking the costs if things go wrong, then the premium paid to private firms is not justified. Now, there are fields where government contracts do meet those criteria and where outsourcing works very well. Cleaning services, for example. And there are some diagnostic or therapeutic services in the NHS where private firms can offer genuinely competitive services. But a lot of the time that doesn't happen. He went on to say, for more complex services though, often none of these criteria apply. Take a specialist activity like running immigration processing. There is no existing market. That means there are few plausible bidders outside of a handful of huge multinational outsourcing firms. That means, as we note, that the UK's outsourcing market is dominated by the big four: Serco, Capita, ASOS and G4S. There must be a very good chance that these companies will end up bidding for assisted dying services. Friedman gives immigration processing as the example of a complex service where you aren't going to get a lot of companies making good competitive bids. Assisted dying is even more complex than immigration processing, and it is even more important to get it right. To bid for assisted dying services, companies will need experience in securing complex government contracts and very good legal advice. They will need to hire doctors and other specialist staff. They will need the facilities to transport and store lethal drugs. We are almost certainly going to see the same old big four outsourcing companies bidding for these contracts, and that would be a major problem because the big four have a terrible record. I apologise for not being able to give a complete list of the scandals that these four firms have been involved in while running government contracts. After all, time is limited, but I think it's worth mentioning a few. In 2013, both Serco and G4S were found to have spent years keeping inaccurate records over how they tagged and monitored dangerous criminals. As a result, they had overcharged the government by tens of millions of pounds. Serco was eventually fined 23 million for fraud and false accounting. G4S was fined 44 million for the same scandal. But that only happened in 2020, 7 years after its fraud was first revealed. I'll just note that these two companies both committed fraud against the taxpayer worth tens of millions of pounds. If any of us...
Can I ask the Honourable Member, please, can we stick to the point and...
I'll bring it back to the point.
Yeah, thank you.
Absolutely. But Serco and G4S carried on getting huge public contracts because the government found it too hard to replace them. And this itself would also be a specialised service. Happy to give way.
She's mentioned a couple of companies there, and I have to say I don't know very much about those companies. Are they healthcare providers? Do they deliver healthcare?
So Serco, some of them do. So they deliver parts of healthcare. So any company can bid or design a service to recruit doctors, as I've talked about earlier. And that's the reason why I've mentioned these companies, is the big companies already do provide some services to our NHS, albeit it might be in different areas at the moment.
Can we just stick to the point,
yes,
please?
Happy to. We should be determined that we cannot see big outsourcing companies bid for assisted dying contracts and then potentially misuse them the way they have misused other public services. Not because I'm opposed to firms operating in a free market, and not because I'm opposed to companies making money when they do their job well. And it's because that way that we run outsourced government contracts in this country often has nothing to do with the free market and nothing to do with companies working well. Finally, Chair, we also need to ask about hard questions about how these contracts would be structured for assisted dying. How would companies be paid a fee for each stage of assisted dying process that they provided? So one fee for providing the first assessment by a doctor, another fee for a second assessment, and so on, up until the final fee for helping the patient take the lethal drugs. And again, in the morning, Chair, we don't know what the proposal of a structure is, and that's why it's important that we explore and understand the risks with every structure. There are government services that we can safely outsource. Assessing whether people are fit to take end their lives is not one of those services, and neither is helping them to take illegal drugs. These clauses will enable future governments to open up lucrative contracts in assisted dying, which will almost certainly be won by some companies which have sometimes been incompetent and potentially been dishonest. I strongly oppose these new clauses. What I will also add, happy to give way.
I'm very grateful. I'm afraid I share all her concerns, and to the Honourable Lady's intervention, is she aware G4S has a health services division in the UK which directly employs doctors and other healthcare professionals?
We've already had the issue.
Okay,
we need to stick to the amendment.
I take your ruling,
Madam
Chair, but the amendment is explicitly about this.
Thank you, Chair. One of the other things I will say is when it comes to NHS providers or any service providers and contracting or outsourcing, the fact is we have legislation in this place for whistleblowers, and only today I've raised that with the Secretary of State for Health in relation to my own local trust. Whether we have the best will in the world, mistakes do happen, and whistleblowers, that we legislated to protect those whistleblowers, and that ties in directly to these risks, and we must do everything we can to mitigate such risks appearing in this bill. Thank you, Chair.
Minister Kinnock.
Thank you very much, Chair, and it's a great pleasure to serve under your chairship this afternoon. The Government remains committed to ensuring the legal robustness and workability of all legislation, and for that reason has worked with the member for Spen Valley on some amendments to the bill. Where changes have been mutually agreed upon by the sponsor and the Government, I will also offer a technical, factual explanation and rationale for these amendments. This will cover amendments 545, new clause 36 and new clause 37 in this group. This group of amendments includes new clauses which relate to clause 32 of the bill. Amendment 525 would remove the Secretary of State's explicit power to make regulations enabling provision of assistance as part of the health service in England and Wales. Therefore, it may prevent such assistance being provided by the NHS. The Secretary of State would still have the power to make arrangements for provision of assistance or to delegate the making of arrangements. However, it would be doubtful that these arrangements could be through the NHS. Rather, the Secretary of State could, for example, make arrangements for another body to provide assistance. Looking at 537, the effect of this amendment as drafted is potentially ambiguous. However, the Government's assessment is that this amendment could be interpreted as allowing regulations to enable provision of assisted dying by a registered charity, whilst not allowing provision as part of the health service. This could put into doubt whether assisted dying could be provided as part of the NHS in England and Wales. 528 would prevent anybody other than a public authority from being authorised by regulations to provide assistance as set out in the bill, regardless of whether that body is contracted by a public authority to do so. This would limit the scope of the Secretary of State's powers to ensure that assistance is available in the absence of a definition. The meaning of public authority might be unclear. Amendment 529 would remove the power to amend, revoke or repeal legislation via regulations made under subsection 1 concerning arrangements for assistance, where these are passed or made before the end of the session in which the bill is passed. This could lead to gaps in the Secretary of State's regulation-making powers and gaps in other legislation. This could also impact on the workability of arrangements for assistance and ultimately the bill. 530 adds 2 requirements when making regulations under clause 32, which sets out the Secretary of State's powers to ensure that assistance is available. Firstly, the Secretary of State may not lay regulations under subsection 1 before either House unless an impact assessment of those regulations is also laid before both Houses. Second, the impact assessment must include an assessment of the impact of the regulations on both the health professional workforce and the NHS itself. An impact assessment is routinely prepared to accompany secondary legislation. However, this amendment would impose a statutory requirement on the Secretary of State to prepare an impact assessment, which would need to be laid before both Houses. As such, this amendment would create a legal requirement that is not the standard for secondary legislation. Chair, clause 32 gives the Secretary of State, this is clause 32 stand part, gives the Secretary of State the power to make necessary provisions so that assistance can be provided in accordance with the bill. 545 clarifies that various regulations made under the bill are subject to the affirmative procedure. This includes regulations about training, qualifications and experience, regulations about when any code of practice comes into force, and regulations about the provision of a voluntary assisted dying service in England and Wales. Whilst regulations about commencement of any codes of practice are already subject to the affirmative procedure, this amendment would mean that regulations relating to the required training, qualifications and experience and about the provision of a voluntary assisted dying service in England and Wales would be subject to increased parliamentary scrutiny compared to the bill as currently drafted. This amendment also clarifies that any other regulations made by the Secretary of State will be subject to the negative procedure. In addition, this clause provides that Welsh ministers may not make regulations in relation to the voluntary assisted dying service unless a draft of the regulations has been laid before and approved by the Senedd. This ensures that regulations about the voluntary assisted dying service in Wales will be subject to increased scrutiny and debate in the Senedd. Chair, New Clause 36 imposes a duty on the Secretary of State to make regulations to ensure that arrangements are made for voluntary assisted dying services to be provided in England. It also imposes a power on the Secretary of State to make other provision about matters that are related to voluntary assisted dying services in England. The regulations made by the Secretary of State can provide that references to the health service in the NHS Act 2006 include references to voluntary assisted dying service in England. This ensures voluntary assisted dying services can be provided via the NHS. The new clause further ensures that voluntary assisted dying services provided as part of the health service must be free of charge unless charging is expressly provided for.
Danny Kruger.
I'm grateful. On the proposed amendment to the NHS Act, will you confirm that, firstly, the implication of this is that under the NHS Act as currently drafted, it would not be possible to deliver assisted dying services? And secondly, can I ask him, just to help me understand the new clause, is it proposed that the government will, by regulation, amend the NHS Act, change the wording of it through statutory instrument, or is it that courts should use this clause to read that original NHS Act in future as inferring that assisted dying is compatible with the NHS Act? Is there an intention to actually change the wording, or is it just that we should now read healthcare to include assisted dying? I would be very grateful because it's not clear to me from the phrasing.
I thank him for that intervention, and the new clause 36 creates the basis for the provision of assisted dying services in compliance with all of the legislation that defines the way in which the National Health Service works. So this amendment, this new clause I should say, as and when, if and when that is passed by this bill committee and ultimately by Parliament, if that is the case, then further amendments and further changes would not be required. This would be the basis for the provision of the assisted dying service within the framework of all of the legislation that defines the way in which the NHS works.
I'm grateful. Just so I understand that, is he not suggesting, as the clause does specify, that the NHS Act itself will require amendment? Is he saying that is not in fact the case?
Minister.
What the clause specifies that the Secretary of State will, by regulation, set out the operating framework for the delivery of the assisted dying service. That will be the change to the legislation that is required. I apologise to him if I'm missing something, but I don't know if we're talking at cross purposes here, but what I am saying is that new clause 36 provides the basis for the delivery of the service. So I'm sorry if I'm missing his point, but that is my understanding.
Will Mr. Give way?
Yes.
I think the point is, and that you're absolutely right, the new clause provides that provision for assisted dying services can be made through the NHS. It does give flexibility if the NHS Act were needed to be amended. It could be, but that is certainly not the intention at this stage. But the NHS Act has been amended on numerous occasions, not least in the recent Health and Social Care Act from 2012.
Minister.
I thank my honourable friend for Spen Valley for that clarification, and I think that's very helpful because I perhaps wasn't quite understanding what the honourable gentleman, the member for East Wiltshire, was saying, and I think she sets out very clearly the optionality that is represented in new clause 36. The new clause further ensures that voluntary assisted dying services provided as part of the health service must be free of charge unless charging is expressly provided for. Subsection 6 confirms that regulations made under this clause can make provisions with the same effect as an Act of Parliament, including amending other primary legislation. However, they could not amend the provisions in this bill. The amendment also defines voluntary assisted dying services. Chair, new clause 36A would prohibit regulations being made which authorise voluntary assisted dying services being provided by the NHS in England. The Secretary of State would still have a duty to secure that arrangements were made for provision of assistance, but not by the NHS. The Secretary of State could, for example, make arrangements for another body to provide assistance. This would mean that the Secretary of State could not ensure assistance in accordance with this bill, that could be provided through the NHS in England. This would only apply to England and not Wales. Welsh ministers could still make regulations for the provision of a voluntary assisted dying services by the NHS in Wales. This could result in a divergence in the provision of assisted dying services between England and Wales. New clause 36B.
I'm just sure he'd be interested to be aware, for the committee to be aware, that the Isle of Man has today passed an Assisted Dying Act, and we already have divergence within the different jurisdictions of the United Kingdom.
Minister Kinnock.
I thank her for that intervention. I think we're all moving in a direction where we would like to have an act that, if the bill, I should say, conditionality being, if Parliament chooses to give royal assent to this bill, or to pass this bill, that the delivery of it in England and Wales is compatible, so ensuring, of course, based on full respect for the devolution settlement, for the legislative consent motions, and so divergence in the context of the devolution settlement is, I think, what the Honourable Lady is certainly keen to achieve, and I think she's working with the sponsor to achieve that aim. This amendment, so this is new clause 36B, seeks to amend new clause 36, tabled by the sponsor. It provides that the Secretary of State must, by regulations, make arrangements for the provision of assisted dying services in England, which provides. The proposed amendment would remove the provision that regulations under new clause 36 may provide that specified references in the NHS Act 2006 to the health service include reference to commissioned assisted dying services. Secondly, it removes subsection 5, which currently states that regulations under new clause 36 must provide that section 1(4) of the NHS Act 2006 applies in relation to commissioned voluntary assisted dying services, which provides that health services must be free of charge unless exceptions apply. Finally, it explicitly provides that regulations under subsection 1 may not amend, modify or repeal section 1 of the NHS Act 2006. If accepted, these amendments may impact the provision of assisted dying services through the health service in England. The effect would be that section 1 of the NHS Act 2006 could not be amended, modified or repealed via regulations under new clause 36 subsection 1. This proposed amendment only applies to England, and the restriction does not apply to Welsh ministers. This could result in a divergence in the provision of assisted dying services between England and Wales, as Welsh ministers could amend section 1 of the NHS Wales Act 2006. New clause 36C. This amendment would limit the scope of the Secretary of State's power in subsection 1 of new clause 36 to make regulations which secure arrangements for the provision of voluntary assisted dying services in England. Under this amendment, such regulations cannot authorise the provision of assistance to be made by a body other than a public authority, if that body was contracted by a public authority to do so. This would effectively prevent the NHS from contracting with private providers to provide assistance. The NHS regularly contracts private providers to provide NHS services. It is possible that being unable to do so here may present operational challenges. This proposed amendment only applies to England, and the restriction does not apply to Welsh ministers. This could result in a divergence in the provision of voluntary assisted dying services between England and Wales. New Clause 36D seeks to amend New Clause 36 and limit the Secretary of State's power to amend, revoke or repeal other legislation for the purpose of making provision for assisted dying services.
I thank the Minister for giving way, and sorry to backtrack slightly, I just wanted to clarify that the Isle of Man is a Crown dependency and not part of the UK, just in light of the conversation that we just had, just to be factually correct.
Mr. Kenneth?
I thank her for that point, and she's absolutely right. So it is a different situation from the point of view of devolution. Of course, perhaps my answer was conditioned by the person that asked me the question and made the intervention, so I was perhaps jumping to conclusions. But she's absolutely right to point that out.
We're also expecting a decision in Holyrood within Scotland, which I think probably everyone in this chamber will agree is part of the United Kingdom. And these are jurisdictions that very much influence what we discuss in places like this.
She makes a very valid point, although of course Scotland has a different legal system to the one that governs England and Wales. So we're back into that debate about the fact that you've got the legal jurisdiction question versus the devolution of the delivery of health services, and it's how to make those two work in a compatible manner is I suppose the key challenge that the Bill Committee is seeking to address. This amendment could limit the Secretary of State's ability to make provision for assisted dying services via the health service in England. For example, it could limit who could commission and regulate assisted dying services, as the Secretary of State will not have the power to amend primary legislation. If this amendment is passed, the Secretary of State would not be able to make the required amendments via regulations to relevant pieces of legislation for the purposes of enabling the provision of assisted dying services in England. The committee may wish to note that, as drafted, this amendment applies only to England and not to Wales, which could lead to a divergence in provisions between England and Wales. New Clause 36E. This amendment adds two requirements to New Clause 36. Firstly, the Secretary of State could not lay regulations concerning the provision of voluntary assisted dying service in England unless an impact assessment on the regulations is also laid before both Houses of Parliament. Secondly, the impact assessment would need to include an assessment of the impact of the regulations on the workforce of health professionals and the NHS in England. An impact assessment is routinely prepared to accompany secondary legislation. This amendment would impose a legal requirement on the Secretary of State to prepare an impact assessment that must be laid before both houses to assess the impact on the workforce of health professionals and on the NHS in England. Practically, this could cause delays in making regulations under the bill by requiring a duplicative impact assessment to accompany each set of regulations, including regulations which make minor and consequential amendments.
Order. The bell is ringing. There are multiple votes. I'm going to suggest that we adjourn for 45 minutes. Order, order. Speech.
Thank you, Chair. I really appreciate that. And I was cut off in my prime, so I'm now ready to start again. Chair, new clause 37 gives Welsh ministers a power to make regulations about voluntary assisted dying services in Wales, including regulations to secure that arrangements are made for voluntary assisted dying services to be provided in Wales. Such regulations can make any provision that could be made by an Act of Senedd Cymru and would be within the legislative competence of the Senedd if it were contained in such an Act. The Secretary of State will be able to make regulations about such services where this would be outside the legislative competence of Senedd Cymru. Subsection 6 confirms that regulations made under this clause can make provisions with the same effect as an Act of Parliament, including amending other primary legislation. However, they could not amend the provisions in this bill. I hope that those observations were helpful to the committee. Thank you, Chair.
Kim Ledbetter.
Thank you, Chair. Sorry, I've just sprinted. Get my breath. Chair, we've had some excellent and extremely thorough debates covering all aspects of this bill since this committee first met. There's been an unprecedented level of scrutiny, rightly so given the gravity of the issue before us. And the clause before us today is one of the most important that we will consider. Without it, the bill's objective of offering a compassionate and dignified choice to terminally ill adults could not be met. The injustices of the status quo would remain, with too many people travelling abroad to seek an assisted death or taking matters into their own hands here at home alone and often before they need to, in order to protect their loved ones from the threat of prosecution. Those people will be left, as they are now, with no protections against coercion or pressure to end their lives, and crucially, no ability to choose the manner and timing of their deaths, so they can say goodbye and be remembered by their loved ones as they would wish to be. Clearly, some honourable members do not want them to have that choice, and they are absolutely fully entitled to that view. However, if Parliament decides otherwise and gives them that choice, it's our responsibility to ensure that it's a choice that can be exercised without adding so many constraints and impediments that would only serve to make their last days and weeks more traumatic, not less. That is one reason, although not the only reason, why I'm clear the process must be available as part of the range of services available to patients under the NHS and free at the point of need. It must be for the Secretary of State to make provision for the service in England and for ministers in Wales to do the same if the Senedd agrees. And the House of Commons must have the opportunity to scrutinise the regulations under the affirmative procedure. Despite the challenges it faces, the NHS is a trusted institution, staffed by some of the best qualified and skilled health professionals anywhere in the world. Not all of them will want to participate, and that is their absolute right. But patients and the wider public should be reassured that assisted dying services would be commissioned and regulated in the same way as other services through the NHS, a system they are familiar with. There's another very important reason why I do not believe voluntary assisted dying should be a service separated from the core responsibilities of the NHS. The Honourable Member for East Wiltshire and others have described the decision to request an assisted death as a fork in the road, but I fundamentally disagree. A fork in the road implies that once you decide which route you're going to take, that's it, and you've chosen your direction of travel. That goes completely against the principles behind this bill. The option of an assisted death is just that. It's an option throughout. Right up until the final moment, the person can decide not to exercise that choice. Experience from around the world suggests that consistently 30 to 40% of people don't. But knowing that they have the option has given them the comfort and reassurance they need to make their final days less stressful and less fearful. I believe it's crucial that the option of a voluntary assisted death remains part of a holistic approach to end-of-life care. If other options, including palliative care or the comfort provided by a hospice or other institution, are working for the individual, they have no need to take it up. But if it remains their clear, settled and informed wish to do so, then that is their decision. My belief that a person requesting an assisted death should be guided through the process in a health and care environment that they are familiar with and trust extends to private provision. Other commissioned and regulated services are supplied by a range of providers, and the same should apply here, as my honourable friend, the member for Sunderland Central, has said. NHS trusts and ICBs may, as they already do, use private providers in some circumstances. This provides flexibility, which is important. But, Chair, what matters is that the safeguards and protections in this bill will apply no matter where the service is supplied. and that the same requirements on doctors will apply, including the need to prepare reports and send them to the Commissioner, and the stipulation that a medical practitioner cannot benefit financially or in any material way from the death of a person and can only receive reasonable remuneration for providing the service. My new clauses 36 and 37 make provision for this. The amendments to these clauses seek to frustrate or delay that intention, and I cannot support them. As a committee, perhaps we are at a fork in the road. One route leads towards the correction of an injustice that has already lasted too long and offers a safe and compassionate choice at the end of life. The other route says we're okay with leaving things as they are, but the status quo is defensible, and people do not deserve to be given that choice. I believe I will give way.
I'm very grateful. I hope he doesn't really persist in thinking that I or others think the status quo is defensible. There are clearly major problems with our palliative care system, which I think we all recognise and want to see improved. So I'd be grateful if she'd acknowledge that we need to improve palliative care. Just going back to her point about remuneration, though, the bill specifies that reasonable remuneration would not be regarded as illegitimate for doctors to earn. What does she think reasonable is? How would we designate what the appropriate remuneration for doctors is? And does she agree that there is nothing in the bill to stop private providers providing the service and making money from it?
I think in terms of reasonable remuneration, which is what I always struggle with, I think it would be the same as any other service commissioned by the NHS. There are tariffs for services that doctors provide. That isn't for us as Parliament to decide. That would be up to the NHS and the commissioning bodies to decide. And I think in terms of private providers, I understand some people might be uncomfortable with that, but I would suggest that if they're uncomfortable with that, they're probably uncomfortable, which might be surprising given our politics, with the concept of private healthcare provision per se. And you know, whatever your moral view on that is, what we can't do is take assisted dying out of the system that we currently have. And I think it's really important that the choice is given to terminally ill patients within the framework that we have. Thank you, Chair.
Danny Kruger.
I'm going to withdraw my amendment, not push any of these ones, because I think we've...
Is everyone content for the amendment to be withdrawn?
Aye.
We now come to Amendment 537 to Clause 32, which has already been debated with Amendment 525. Does any member wish to move the amendment formally? We now come to Amendment 528 to Clause 32, which has already been debated with Amendment 525. Sarah Olney, do you wish to move the amendment formally?
I think this is an amendment to Clause 32 which is being withdrawn, so I withdraw my amendment to Clause 32.
Is everyone content for it to be withdrawn?
Aye.
We now come to Amendment 529 to Clause 32, which has already been debated with Amendment 525. Sarah Olney, do you wish to move the amendment?
No, withdrawn, Chair.
Is everyone content for it to be withdrawn?
Aye.
We now come to Amendment 530 to Clause 32, which has already been debated with Amendment 525. Sarah Olney again, do you wish to move the amendment?
No, withdraw, Chair.
We now come to the question, the Clause 32 stand part. The question is that Clause 32 stand part of the bill. As many of that opinion say aye.
Aye.
Of the contrary, no.
No.
Division. Sorry. Lock the doors.
Jack Abbott.
No.
Lewis Atkinson.
No.
Juliet Campbell.
No. No.
Lambos Chow Lambos.
No.
Daniel Francis.
No.
Tom Gordon.
No.
Sarah Green. No. Rachel Hopkins. No. Joan Joseph.
No.
Stephen Kinnock.
No.
Danny Kruger.
No vote.
Kim Leadbeater.
No.
Kit Malthouse.
No.
Sarah Olney.
No.
Rebecca Paul. Abstain. Jake Richards.
No.
Sarah Sackman.
No.
Liz Saville Roberts. Liz Saville Roberts.
No.
Naz Shaw,
No.
Dr Neil Shestry-Hurst,
No.
Dr Mary Tipple,
No.
Sean Woodcock.
No. Well, okay.
The noes 20, the ayes 0. The noes have it. We now come to Amendment 539 to Clause 33 in the name of Kim Ledbetter, with which it will be convenient to consider amendments 172, 540 to 544, 173, Clause 33, Stan Platt, new Clause 38 and new Clause 39. I call Kim Ledbetter to move Amendment 539.
Thank you very much, Chair. Chair, the purpose of these amendments is to enhance the effectiveness and efficiency of the notification process within the context of the bill, and to ensure that the Commissioner, who plays a key role in monitoring and reporting, receives the necessary information to fulfil their duties effectively. The amendments we're considering aim to empower the Secretary of State to make regulations that will require registered medical practitioners to notify the Commissioner of any events specified in these regulations. This change is a critical step towards centralising the notification process, ensuring that the Commissioner is directly involved in overseeing these events in a manner that supports the broader goals of the legislation. Under these amendments, the Secretary of State would have the authority to make regulations that require medical practitioners to notify the Commissioner and grant the Commissioner the power to request information. These amendments are designed to enhance the Commissioner's ability to effectively monitor the operations of the Act. New clauses 38 and 39 are designed to facilitate the proper and secure exchange of information between the Commissioner, various regulatory bodies and the Secretary of State in relation to the voluntary assisted dying framework. These provisions are critical to ensuring that the operations of this Act are transparent, effective and that they operate within a secure, legally compliant framework. New Clause 38 seeks to create a structured system for the exchange of information between the Commissioner and key bodies involved in healthcare regulation and oversight. This is an essential provision to ensure that all relevant parties can cooperate in the administration of the Act and that the Commissioner has access to the necessary data to fulfil their duties effectively. New Clause 39 addresses a critical issue regarding the disclosure of information under the bill, ensuring that information can be shared as required without compromising data protection laws or breaching confidentiality obligations. The clause seeks to make sure that while the bill facilitates necessary data sharing, it will not override existing protections in place for privacy and confidentiality. This is crucial for both professionals and individuals involved in the processes established by the bill. New Clause 38 and New Clause 39 ensure that the Voluntary Assisted Dying Commissioner can effectively share information with key bodies while maintaining strict adherence to confidentiality and data protection laws. Thank you, Chair.
Rebecca Paul.
Thank you.
Oh, sorry. Amendment 539 to Clause 33 as on the amendment paper. The question is that the amendment be made. Rebecca Paul.
Thank you, Chair. I rise to speak very briefly to my amendments 172 and 173. So Amendment 172 will drop away if Amendment 539 is voted through. But the point of Amendment 172 was just to ensure that the Commissioner has adequate data about important events. It turns a may into a must. It means that the Secretary of State must issue regulations requiring a doctor to notify the CMO or the Commissioner, as in all likelihood it will be, of any notifiable event. I note that Ledbetter 539 entirely removes subsection 2, which lists what a notifiable event is. So gone is the list of what should at a minimum be included, the witnessing of the first declaration, the first assessment, second declaration, refusing to make a statement, etc. So that seemed a reasonable list to me, and I'm not quite sure why it has been removed and left up to the Secretary of State to decide. So it seems to be a watering down of the type of events that must be notified, as these new amendments allow much more discretion as to what is requested. It seems eminently sensible to me that a doctor should notify the Commissioner of all the various stages of the process, but this is unlikely to be the case now with or without my amendment. Moving on, Amendment 173 means that any regulations made under this section... I will, of course, give way.
I thank you for giving way. I will double check, but I'm pretty confident that those reporting mechanisms are covered elsewhere in the bill, particularly in earlier clauses, but I'm very happy to confirm that I think clauses 7 and 8 cover it. Thank you.
I thank the Honourable Lady for that intervention, and that would be very reassuring if that were the case, because I do think this data can be very useful by just making sure we get into the routine of providing it. Then it's there if we ever need it. Moving on, Amendment 173 means that any regulations made under this section must be made under the affirmative rather than the negative statutory instrument procedure. In the interests of using our time well, I won't repeat the arguments that have already been made last week on this, but I would just point out with this clause, as amended by 539, the bill is once again deferring a lot to ministerial powers and to non-binding guidance and codes of practice. And with the negative procedure, Parliament is reduced to just watching rather than properly participating in the decision-making process. Thank you.
Thank you, Chair. I rise to speak in support of Amendment 172 and 173, tabled by the Honourable Lady for Reigate, and also the against Amendment 539, moved by the bill sponsor, Honourable friend from Spen Valley. Clause 33 currently states that the House Secretary may bring forward regulations that a doctor must report any notifiable event to the Chief Medical Officer. That would be either the CMO for England or for Wales, according to where the assisted death takes place. Clause 33 lists such notifiable events, including the first declaration by the death, the 2 statements by the doctors, including when they refuse to make such a statement, and the final statement that follows the person's death. I think the weakness in the clause as originally written is its use of the word may. It should not be optional for the Secretary of State to make such regulations. Amendment 539 keeps that weakness in the original clause 33, while adding what I view as a new problem. The new weakness that I think this amendment introduces is that it removes the requirement for doctors to notify the CMO of these events. Instead, it specifies that they should notify the Voluntary Assisted Dying Commissioner. By all means, let us have doctors report these events to the Commissioner, but they should still have a requirement to also report the events to the Chief Medical Officers. There are at least 2 good reasons for this. The first is that the Chief Medical Officers are extremely experienced and senior doctors. They and their staff have the ability to look at this kind of data from a medical and especially a public health perspective. The VAD Commissioner will come from a legal, not a medical background. They will have other abilities, but they will not look at this in the way of a lens of a senior doctor would. The second reason is that it cannot be good governance that the only person who must see the data is the Commissioner, the official who runs the assisted dying system and who appoints all the panel members. As I'm happy to give way.
Just on that point, I hope you can provide some reassurance from my Amendment 455, which I think we voted on already, which says that the Commissioner must consult with the Chief Medical Officer for England and the Chief Medical Officer of Wales when they're making their report.
I thank the Honourable Member for her intervention, and I was coming on to that, and I will address it. As I said previously, this bill will not just create a Voluntary Assisted Death Commissioner, but will give them the power to assess their own work. That means it is much less likely that they will critically assess the data for any signs of a major problem. We all suffer from unconscious bias, even the very senior legal officials who will be eligible to become VAD commissioners. If the data was sent to the Chief Medical Officers as well as the Commissioner, that would mean 2 sets of officials with different perspectives and different fields of expertise were both looking for problems. We would have a much better chance of locating problems earlier that way. I now turn to the Honourable Member for Reigate's Amendment 173 and 174. The first amendment, 173, would change the clause so that the House Secretary must bring forward such amendments. As things currently stand, regulations brought forward under the clause would be subject to a negative procedure. As all honourable members will be aware, this considerably reduces the amount of parliamentary scrutiny and any such regulations would receive. The second amendment, number 173, would change the clause so that they are subject to the positive procedure. I do honestly try to see that the arguments for and against every amendment are, and I'm afraid I have real difficulty in seeing what arguments against these 2 amendments might be. Clearly, the notifiable events are all important information which need to be collected nationally if we are to have a properly assisted, transparent assisted dying system. Equally clearly, they need to be governed by regulations so that all doctors participating in the scheme have a clear picture of what their responsibilities are. And finally, in a matter of this importance, Parliament should have to vote to accept such regulations that will increase the scrutiny that this House and the other place pay to them. In response to the honourable member's intervention, I appreciate she drew my attention to her amendment, which says that the Commissioner must consult the Chief Medical Officer. That consulting, what it doesn't do is specify, does that in consultation include data? Is it at the beginning of the process? It doesn't say it on the face of the bill. So that can be left to open for interpretation, which is why I'm supporting the Honourable Member for Reigate's amendments. I thank the Honourable Member for tabling these two very sensible amendments, and I do urge members to vote for them. And I'm afraid that, from my perspective, Amendment 539 weakens the bill, and we should vote against it. Thank you, Chair.
Minister.
Thank you very much, Chair. Chair, I'll take Amendment 539 to 544 together. These amendments seek to ensure that the Voluntary Assisted Dying Commissioner can receive the information necessary to fulfil their functions in monitoring the operation of the bill. Amendment 539 empowers the Secretary of State to make regulations requiring the registered medical practitioners to notify the Commissioner, instead of the relevant Chief Medical Officer, of any event specified in such regulations. This could include the events currently listed under subsection 2, such as where a practitioner carries out a first or second amendment and provides or refuses to provide a supporting statement. Setting out these events and regulations would allow for greater flexibility. Amendment 540 empowers the Secretary of State to make regulations enabling the Commissioner to require specified persons or specified descriptions of persons to provide information. For example, this could be access to medical records to inform panel deliberations. The regulations made by the Secretary of State under Amendments 539 and 540 may also provide for how such regulations are to be enforced. The enforcement mechanism would help ensure compliance with the provisions regarding notification and provision of information to the Commissioner under the regulations. 541 to 544 are consequential amendments. Turning to 172, as introduced, Clause 33, subsection 1 provides that the Secretary of State may, by regulations, require any registered medical practitioner to notify the relevant Chief Medical Officer, or CMO, of any notifiable event. A list of such notifiable events is provided in Clause 33, subsection 2. The effect of Amendment 172 would be that the Secretary of State would instead be required to make regulations under Clause 33, subsection 1, that is, to make regulations which require any registered medical practitioner to notify the CMO of any notifiable event. Amendment 173 requires that any regulations made under Clause 33 would need to be made under the affirmative rather than negative procedure, meaning that they would be laid before and approved by both Houses of Parliament. Turning now to new Clause 38. The purpose of new Clause 38 is to allow the sharing of information between the Voluntary Assisted Dying Commissioner and certain persons. New Clause 38 would create an information sharing gateway between the Voluntary Assisted Dying Commissioner and the Care Quality Commission, the General Medical Council, the General Pharmaceutical Council, and the Nursing and Midwifery Council. The clause includes a regulation making power for the Secretary of State to specify any other person that the Commissioner may share information with, and vice versa. The clause also creates an information sharing gateway between the Commissioner and the Secretary of State to enable sharing of information for the purpose of any function of the Commissioner or any function of the Secretary of State where it relates to the operation of the bill. New Clause 39 provides that where there is a disclosure of information that is required or authorised under the bill, this will not amount to a breach of confidence or any other restrictions placed on the disclosure of information. The amendment makes clear that data protection legislation still applies and will need to be complied with. It is essential that any provisions under the bill which require data to be shared do not undermine the public's trust in security and privacy in terms of their personal data. I hope that those observations were helpful to the committee. Thank you, Chair.
Kim Ledbetter.
I've got nothing further to add, Chair. Thank you.
Amendment 539 to clause 33 as on the amendment paper. The question is that the amendment be made. As many of their opinion say aye. Aye. To the contrary, no. No. Division. Lock the doors.
Jack Abbott. Lewis Atkinson.
Aye.
Juliet Campbell.
Aye.
Bamble Chow Lambeth.
Aye.
Daniel Francis.
Aye.
Tom Gordon.
Aye.
Sarah Green.
Aye.
Rachel Hopkins.
Aye.
Sojourn Joseph.
Aye.
Stephen Kinnock.
Aye.
Danny Kruger.
No.
Kim Leadbeater.
Aye.
Kit Malthouse.
Aye.
Sarah Olney.
No.
Rebecca Paul.
No.
Jake Richards.
Aye.
Sarah Sackman.
Aye.
Liz Saville Roberts. Naz Shah.
Aye.
Dr Neil Shastri-Hurst.
Aye.
Dr Marie Tibble.
Aye.
Sean Woodcock.
Aye.
The ayes were 19, the noes 3. The ayes have it, the ayes have it. Unlocked. Clause 33, Amendment 159. Liz Saville Roberts, do you wish to move the amendment? We now come to Amendment 172 to Clause 33, which has already been debated with Amendment 539. Rebecca Paul, do you wish to move the motion? Move the amendment formally?
Does it not fall automatically as a result of 539? If not, I'm happy to move it to a vote. I thought it probably falls.
Move forward. No. Okay, forward. Okay, thank you. No, next one. We now come to Amendment 540 to Clause 33, which has already been debated with Amendment 539. I call Kim Leadbetter to move the amendment formally.
Move formally, Chair.
Amendment 540 to Clause 33, as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. We now come to Amendment 541 to Clause 33, which has already been debated with Amendment 539. I call Kim Leadbetter to move the motion formally.
Move formally, Chair.
Amendment 541 to Clause 33, as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. We come to Amendment 542 to Clause 33, which has already been debated with Amendment 539. I call Kim Leadbetter to move the amendment formally.
Move formally, Chair.
Amendment 542 to Clause 33, as on the amendment paper. The question is that the amendment be made. And as many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. We now come to Amendment 543 to Clause 33, which has already been debated with Amendment 539. I call Kim Leadbetter to move the amendment formally.
Move formally, Chair.
Amendment 543 to Clause 33, as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 544 to Clause 33, which has already been debated with Amendment 539. I call Kim Leadbetter to move the amendment formally.
Move formally.
Amendment 544 to Clause 33, as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 219 to Clause 33, which has already been debated with Amendment 187. I call Kim Leadbetter to move the amendment formally.
Move formally, Chair.
Amendment 219 to Clause 33, as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. We now come to the question, the clause 33 as amended stand part. The question is the clause 33 as amended stand part of the bill. As many of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. We now come to Amendment 382 to Clause 34 in the name of Kim Ledbetter, with which it would be convenient to consider Amendments 383, 384, 385, 449, 386, 387 and 389. I call Kim Ledbetter to move Amendment 382.
Thank you very much, Chair. Amendment 382 and the consequential amendments provide for monitoring, investigation and reporting functions under Clause 34 to be carried out by the Voluntary Assisted Dying Commissioner. The Commissioner will submit an annual report to the appropriate national authority, Parliament or the Senate, on the operation of the Act as set out in Amendment 389. And the appropriate national authority must publish any report received under this section, prepare and publish a response to any such report, and lay before Parliament or the Senate, Cymru as the case may be, a copy of the report and the response. I think the committee is in agreement, Chair, about the importance of reporting and monitoring under the Act, and as such I hope they can support these amendments.
Danny Kruger. Oh, sorry, Amendment 382 to Clause 34 as on the amendment paper. The question is the amendment be made. Danny Kruger.
I'm very grateful, and I do appreciate that these amendments are necessary to the new design of the bill, but I just wanted to express my concern that they establish an assisted dying regime which is left to monitor itself. When the person who facilitates these profound decisions is also the one reviewing them, I think we face risks that threaten not just the system's integrity, but the safety and the trust of those it serves. And without labouring the point, I do want to point to other jurisdictions where we have significant problems about the reporting and the information being the responsibility of the people who are delivering the service. So in Oregon, where it's been legal since 1997, the state relies on doctors to self-report compliance. We're left trusting that every form filled in will tell the whole story. In Victoria, in Australia, Robert Clark, who's the former Attorney General there, very concerned about the operation of the legislation in Australia, has highlighted how the Voluntary Assisted Dying Review Board, similar arrangement to the commission that's proposed here, relies on paperwork from the doctors themselves with no routine audits or real-time checks. And he pointed out that a tiny group of doctors, in fact only 10, handled 55% of all cases in 2023-24, according to the Review Board's own data. Many of those doctors themselves were advocates for the legalisation of the programme. So I am concerned about the implications of a system which effectively trusts the doctors to provide information without any proper review. And lastly, Madam Chair, just to point out, I do feel, with all respect to the likely, whoever it is who's going to come in as the Commissioner, the elevation of this particular role, or rather the replacement of the CMO, the Chief Medical Officer, with the Commissioner, I do think represents a downgrading of the scrutiny that the bill offers. We know the Commissioner is likely to be a retired judge. Now, that's a very distinguished position. Nevertheless, it's not somebody with the status, with serious political status, as the Chief Medical Officer does. The CMO is a role equivalent to a permanent secretary. I mean, I'm sure the Honourable Lady acknowledges that our current CMO is probably the best-known public servant in the country. I think it's very significant that we're proposing to downgrade the role fulfilled by the CMO with a retired High Court judge. I don't think he'll have the same status. I'll give way.
I thought he was quite keen on a judge, but now maybe less so. But I think hopefully, again, he's reassured by Amendment 455, which talks about the Commissioner having to consult with the Chief Medical Officer. And that is a really clear intent from a policy perspective to have judicial and medical expertise and oversight.
Danny Kruger.
I'm very grateful. I'm keen on actual judges sitting in court with the full authority of a judge, not a retired judge sitting at the head of a quango very far away from the decisions that are being made about assisted dying. But I am grateful to the Honourable Lady, and of course she is right, that I do appreciate the fact that there will be a duty to consult, and we do want to have as much input from the CMO as possible over the administration of the service. Thank you.
Nash Shah.
Thank you, Chair. I'm wanting to, I'm speaking to on the Amendment 382, moved by the Honourable Member for Spen Valley. Let me say briefly at the outset that my honourable friend may argue that some of my criticisms of this amendment are answered in two more of the amendments, as she just has done, and that she has tabled in particular 455 and 456, and indeed I took an intervention earlier on those. Those amendments were originally grouped with this one, Chair, until this morning, so I have speaking separately to them. I have read those amendments and I regret to say that they don't answer my concerns about Amendment 382 in particular. I had planned to talk about them now, but the grouping has changed and I will address 455 and 456 in my next speech. I think this is a good moment to pay tribute to the extremely hard work of the committee's clerks. I thank them for the way they have coped with complex groupings and huge numbers of amendments, and I think unprecedented for a private member's bill this century. Going back to this amendment, the Honourable Member's explanatory statement gives a very clear explanation of what Amendment 382 does. It provides for monitoring, investigation and reporting functions under Clause 34 to be carried out by the Voluntary Assisted Dying Commissioner instead of the Chief Medical Officers for England and for Wales. I can think of two possible arguments in support of it. I don't know if any of them were behind my honourable friend's decision to table the amendment, but these are the best ones that come to my mind, certainly. The first argument is in favour that the Chief Medical Officer for England and Wales already have a great many demands on their time. Honourable members could say we should not risk overloading them. Instead, we should give the function of looking at how assisted dying systems work to another official. The second is that the amendments to this bill create a voluntary assisted dying commissioner. That person and their officials will build up expertise in that field. So it could be argued that the commissioner would be the best person to lead monitoring, investigation and reporting. Unfortunately, I don't think these arguments hold water to deal with the first one. It is true that CMOs have a great deal to do. But if we pass this bill, it will be one of the biggest changes that has been made to the duties of doctors in this country. For the first time, they will be able to help patients take lethal drugs solely in order to bring about their death. The Chief Medical Officer of England for England and Wales are senior doctors who advise government on all medical matters. Of course, they should be centrally involved in seeing whether this system works and if there are any problems. Let me turn to the second possible argument in favour of Amendment 382, that the Commissioner's Office will become the subject matter experts in assisted dying. I think that doesn't stand up either. And the reason is, it is true that the Commissioner and the officials they recruit will come to know a great deal about the system they set up. But it's the very fact that they will set it up and run this system that means we should not have them as the people who take the lead on monitoring, investigating and reporting. That would mean that the Commissioner and their staff will be the first people who decide if they are doing a good job or not. Asking people to mark their own homework is a really bad way of checking that any system is working properly. It's not how we inspect and report on schools where Ofsted has the job, not the head teachers or the local councils. It's not how we regulate banks, which are overseen by independent authorities. Yes, happy.
Rachel Hopkins.
If I may just pick up that point about marking your own homework, does she agree that many public bodies actually do a self-assessment that is then looked at by the regulator? So actually it is a really important part of the process of self-regulation as much as external inspection.
I thank my honourable friend for her intervention, but there isn't a regulatory system that's been proposed that I've seen in regards to this bill. I'm happy to stand to be corrected. But in other instances, yes, we have regulators, but in this instance, there isn't a regulator, and that's not specified, which is why I come back to my amendment, but I value her intervention. So, it's not how we regulate banks. We are overseen by independent authorities. We've seen what happens when there was a light touch regulation. Banks told us all that they were going to do a great job, until it turned out that they weren't. There is an Independent Police Complaints Commission. I could go on, the list is very long, but I would hope we all agree on the principle. When we think about how to regulate an important system in this country, we shouldn't allow the people who run it to be the only people to tell us whether it is working as it should. Even though we respect the highly skilled people who run our schools or who police our streets, we have independent people whose job it is to check whether there are any major issues. The assisted dying system this bill creates is both complicated and potentially very dangerous. If the system gets things wrong, it will mean people will be given lethal drugs who should not have had them. That is why I would strongly support keeping the chief medical officers as the people who run monitoring, investigating and reporting. Perhaps there could be a dual system in which both the CMOs and the VAD Commissioner have some kind of role there. That would at least be an improvement on allowing the Assisted Dying Commissioner to say that there's nothing to see here. But in my view, the best choice would be to retain the system this bill started out with, keeping the chief medical officers as the people with the main responsibility and for oversight. I know members disagreed with my comparing assisted dying to the scandal of what happened to the sub-postmasters and mistresses, but we have to think about what we've learned about the causes of that. Under the law, ministers had responsibility for post office, even though it was an arm's length responsibility. They still had it. When complaints about the Horizon IT system and then complaints about miscarriages of justice started to come through to MPs, the ministers asked the experts in the field. Who were those experts? The executives who ran the post office and the engineers at Fujitsu who had set up and then ran Horizon system. And what did those experts say for about 15 years? There was no serious problems with Horizon, that the sub-postmasters and mistresses who said otherwise were lying and that all their convictions were safe ones. We know how that turned out. And that surely leads us to a very clear lesson. We can't ask powerful people who have created a system, and in this case the assisted dying system, are in charge of it, to be the ones who report on it. I am not saying we would see a deliberate cover-up, as we seem to have had in the post office scandal. What I am definitely saying is that we all have unconscious biases, and all of us are biased to think that the work we do is good and that there are no serious problems with it. In my view, the amendment significantly weakens the bill from the version that was presented to the House at second reading. We are being asked to let the Commissioner report on their own work. This makes it much less likely that we would be able to spot any problems with the assisted dying system at an early stage. And therefore, I urge honourable members to vote against this amendment.
Minister Sackman.
Thank you, and it's a pleasure to serve under your chairship. Chair, I will first speak to Lead Amendment 382 in the name of the member for Spen Valley, and then the consequential amendments 383, 384, 385, 386, 387 and 389, which the Government has worked on with the bill's sponsor. As committee members will know, as the bill currently stands, the relevant chief medical officers are required to submit an annual report to the relevant national authority. The effect of these amendments would require that the monitoring, investigation and reporting functions under current clause 34 are carried out by the voluntary assisted dying commissioner, as opposed to the chief medical officers for England and for Wales. These functions are to monitor the operation of the Act, including compliance with its provisions and any regulations or codes of practice which are developed, to investigate and report on any matter connected with the operation of the Act, including those which have been referred to the Secretary of State or Welsh ministers, and submit an annual report. The Secretary of State or the Welsh ministers would be required to lay the Commissioner's annual report before, respectively, Parliament and the Senate, and issue a formal response. In relation to Amendment 449, which deals with annual report duties, this has been tabled in the name of the member for York Central. The amendment would additionally require the relevant Chief Medical Officer in the current text of the bill, not accounting for the amendments brought forward by the members for Spen Valley, to submit the annual report to Parliament for England and the Senate for Wales. This amendment would confer a duty on the Chief Medical Officer for Wales, which could encroach on the executive competence of the Senate. If this amendment were to be agreed, further devolution consideration would be required. I hope that these observations are helpful to members of the committee in considering the bill.
Kim Ledbetter.
I've got nothing further to add, Chair.
Amendment 382 to clause 34, as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. We now come to Amendment 383 to clause 34, which has already been debated with Amendment 382. I call Kim Ledbetter to move the amendment formally.
Move forward, Chair.
Amendment 383 to clause 34 as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. We now come to Amendment 384 to clause 34, which has already been debated with Amendment 382. I call Kim Ledbetter to move the amendment formally.
Move formally, Chair.
Amendment 384 to clause 34 as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. We now come to Amendment 385 to clause 34, which has already been debated with Amendment 382. I call Kim Ledbetter to move the amendment formally.
Move formally, Chair.
The Amendment 383 to clause 34 as on the amendment paper. The question is that the amendment be made. Does many of that opinion say aye? Aye. On the contrary, no. I think the ayes have it. We now come to Amendment 449 to clause 34, which has already been debated with Amendment 382. Does any member wish to move the amendment formally? 449. We now come to Amendment 386 to clause 34, which has already been debated with Amendment 382. I call Kim Ledbetter to move the amendment formally.
Move formally, Chair.
Amendment 386 to clause 34 as on the amendment paper. The question is that the amendment be made. Does many of that opinion say aye? Aye. On the contrary, no. I think the ayes have it. We now come to Amendment 450 to clause 34 in the name of Rachel Maskell, with which it will be convenient to consider amendments 451, 455, 456, new clause 33 and new schedule 3. Does any member wish to move amendment? I call Naz Shah to move amendment 450.
I stand to move Amendment 450 and 451 tabled by my honourable friend for York Central. Let me first set out broadly what it does. It would mean that the reports of the Chief Medical Officers for England and Wales would have to include qualitative as well as quantitative data on assisted deaths. Subsection 2 of Clause 34 currently says that the Chief Medical Officer's reports must include information about when 4 different events happen. Those things are that either of the examining doctors refuses to make a statement saying the person is qualified for assisted dying and does not pass the test set by the bill, or if the panel decides the person does not pass those tests, or if the coordinating doctor decides that the person's final statement does not pass these tests. This amendment would add that Chief Medical Officers for either England or Wales would have to report on patients' diagnosis and prognosis, concerns raised about capacity or about the patient being coerced, and any concerns raised by the panel or family members. The CMO's reports under this amendment would also have to include data on the patients, including information on their socio-economic data and their protected characteristics under the Equality Act 2010. It would also have to include information that the doctors had gathered during their consultations with people seeking assisted death. I think I can anticipate that members may object to the term socio-economic data term is vague. I think it is important to note that the Chief Medical Officer's reports on other matters already make considerable use of socio-economic data. For example, the CMO for England's 2024 report on health in cities gave detailed information on urban populations' socio-economic categories. This report looked at urban populations by indices of multiple deprivation and ethnicity and how those factors interacted with their health. The CMOs for England and Wales are used to working with this kind of data. Indeed, they say in reports that using this type of information is vital to understanding the health needs of different parts of the population. We should take this approach to understanding the people who access assisted dying, who they are, where they live, and which groups they belong to.
We think there are 6 votes, so we will reconvene at 17:15, Mr. Woodcock. vote in the division on clause 32, and we can't start because Naz is not back. In favour of the proposition, it is clear the division shouldn't have been called. Therefore, no division will be recorded in the proceedings. And we're waiting on Naz Shah. Okay, well, in the meantime, Sarah Olney.
Oh, hang on, you proposed that. She hasn't actually moved the amendment.
Okay, no, Sarah, Naz, we're waiting for you. Oh, she's going to finish her speech now. Okay, Naz Shah.
Thank you, Chair. So I was talking about Amendment 450 and 451, and I was explaining why we should take this approach in understanding the people who access assisted dying, who they are, where they live and which groups they belong to. We have heard frequently, for example, for some honourable members, that assisted dying in other countries is disproportionately accessed by people with above average income. They have cited this data from other countries as a reason why we should be reassured that this bill will not have harmful effects on people from, say, ethnic minorities or from economically disadvantaged backgrounds. I am sure honourable members want us to gather the same information in England and Wales to ensure that people with protected characteristics or people from disadvantaged communities were not harmed or discriminated against. That has covered what this amendment will do. I now want to talk about why I think it would improve the bill. This amendment would increase the amount of qualitative as well as quantitative data in the CMO's reports. That kind of data has all kinds of benefits. It can improve the training for healthcare professionals. It will also make it easier for researchers to dig into the kinds of trends that they see in the data. I think we all agree that if we have assisted dying in this country, it must be a much more transparent process than the one we see, say, in Australia. My honourable friend, the sponsor of the bill, has introduced Amendment 455 that requires the report to include some of the information this amendment would add. I will deal with Amendment 455 in more detail in another speech, but I will just say that I am glad that my honourable friend recognises the importance of reporting on protected characteristics. One of the other things this amendment would do is to oblige the chief medical officers to report on complications that people may suffer during their assisted deaths. I am sure all colleagues will agree that this is a vital topic for the CMA to gather data on. If we have assisted dying, we need to understand how often complications occur and what kind of factors they are associated with. That information can be used to give people an informed choice over whether they choose an assisted death. It can be used, perhaps most importantly, to reduce the number of assisted deaths where people suffer painful complications. And it will inform our decisions in this House if we have to amend legislation or vote upon regulations. The amendment says that CMOs must report on the diagnosis of people who apply for assisted death. That is an extremely important provision. Given the CMOs a duty to do that would mean that they will be looking for patterns of diagnosis. Doing so makes it very likely that either the CMOs or other researchers using the same data would spot any particular conditions presented, special problems or for palliative care. Identifying those problems will give us the impetus we need to look at whether and how the NHS can improve palliative care for those conditions. For similar reasons, it is important that CMOs should look at cases where people involved in the process raised concerns about a person's capacity or about coercion. I understand that the Voluntary Assisted Dying Commissioner has a duty to report on these and other matters. But honourable members surely agree that this question is so serious that we cannot just allow just one official to report on possible concerns. This is particularly true because the Voluntary Assisted Dying Commissioner is the person who appoints panel members and rules on appeals against decisions. I have said this before and I will say it again. It is never a good idea to allow anyone powerful to mark their own homework. This is a clear case where we need other senior officials looking at the data for signs that things are going wrong. I anticipate that the Minister is very likely to say that the Government can see problems with this part of the amendment. That is because he has given that response before to amendments that use the word complications. The Minister has said before that it is the Government's view that it is not clear what the word means. Therefore, the Minister has told us we cannot impose duties on doctors or other people using the word complications. This is something that troubles me, and I would like to explore it in depth with the Minister. But the bill's text as drafted actually uses that word, and it uses it in the same sense in which it is used within this amendment. I refer to the Minister to Clause 9, subsection 2. The relevant part of that clause reads, "The assessing doctor must discuss with the person their wishes in the event of complications arising in connection with the self-administration of an approved substance under Section 18. The Minister will agree, I'm sure, that if we can accept the word complications in Clause 9 to describe unwanted or unpleasant circumstances during and after the self-administration of lethal drugs, we can accept it when it is used in the same sense in Amendment 451. If he still objects to the word when it is used outside Clause 9, I think I would be happy to have a detailed explanation, and I think it's important to have that as to why. Let me now turn to the second of my honourable friends' amendments, number 450. This says that the Chief Medical Officers must produce an annual equality impact assessment concerning access to both palliative care and assisted dying. They would have to do so on the basis that the protected characteristics as set out in the Equality Act 2010, socio-economic status and geographical location. Now, I understand that the bill sponsor has tabled an amendment that would require the Commissioner to report on people with protected characteristics, but that would only look at how those people were affected by assisted dying. That doesn't go far enough. Several of the doctors and other experts who gave evidence to this committee said they feared that people might be more likely to choose assisted dying if they had no access to good palliative care. Several experts told us that whether you can get good palliative care varies very much according to where you live. We should not just shrug our shoulders and say that it is a terrible shame that palliative care is in bad shape in some parts of the country while it is good in others. To conclude, Amendment 451 would mean that Chief Medical Officers and their teams use their ability and their knowledge to scrutinise the assisted dying system. Their reports would help us identify serious problems early and then to deal with them. Amendment 450 would give Parliament the regular information it needs about whether people in this country can access palliative care. If we are serious about improving people's ability to have good quality care at the end of their lives, we should support it, and I urge honourable members to support these amendments. Thank you, Chair.
Amendment 450 to Clause 34, as on the order paper. The question is, the amendment been made? One moment. I'm going to suspend the sitting for about 3 minutes, and I want the broadcasting off, please. Is that okay? Sitting suspended for 3 minutes. Sarah Olney.
Thank you very much, Sir Roger. It's a pleasure to serve under your chairmanship. I rise to speak in support of new Clause 33 and new Schedule 3. I'm concerned that Amendment 455 is inadequate to maintain trust in the system. Collecting comprehensive data in an assisted dying regime, such as the detailed statistics outlined, serves several critical purposes. These reasons revolve around ensuring transparency, accountability, safety, equity, and continuous improvement of the system. And it's about ensuring from the very start that there is good data, learning from the paucity and blanks in other regimes and where they have been criticised. The Secretary of State would have the power to amend the schedule, but it would be crystal clear what Parliament's intent is and the expectation we have that the system will be scrutinised. We need to collect data for monitoring and oversight, gathering detailed information about individuals requesting assisted dying and the process itself. It allows regulators to monitor how the system is functioning. This helps ensure that law is being applied consistently and fairly, preventing misuse or abuse. We need to safeguard our vulnerable population. Data on characteristics like age, ethnicity, disability, mental health conditions and deprivation indices can reveal whether certain groups are disproportionately seeking or being denied assisted dying. This helps identify potential coercion, discrimination or gaps in care, and that might drive requests, ensuring the system protects vulnerable individuals. For the purpose of improving healthcare and support services, information about prior involvement with palliative care or psychiatry teams, as well as referrals made after requests, highlights whether patients are receiving adequate support before opting for assisted dying. If data shows low referral rates or unmet needs, it could prompt improvements in healthcare access or quality, potentially reducing the number of requests driven by untreated suffering. For the purpose of evaluating the process, tracking timelines, i.e. from initial discussion to death, and procedural steps like second opinions and panel decisions, ensures that the process is efficient yet thorough. It can reveal bottlenecks, delays or inconsistencies, allowing policymakers to refine the system from both patients and clinicians. For the purpose of understanding motivations and outcomes, collecting the reasons for requests, refusals and complications such as the drug efficacy or adverse reactions provides insight into why people seek assisted dying and how the process unfolds. This can inform public policy, clinician training and patient counselling, ensuring that decisions are well-informed and voluntary. For the purpose of ensuring accountability, data on clinicians, pharmacies and panel decisions creates a transparent record of who is involved and how often. This helps prevent over-reliance on a small group of professionals, ensures that ethical standards are upheld and allows for audits if concerns arise. For the purpose of public trust and ethical debate, detailed statistics foster transparency, which is essential for maintaining public confidence in a sensitive and controversial practice. They also provide evidence for ongoing ethical and legal debates, enabling society to assess whether assisted dying aligns with its values and goals. And for the purpose of learning and adaptation, by analysing complications, drug effectiveness and reconsideration requests, authorities can refine protocols, e.g. adjusting approved substances or dosages, to make the process safer and more humane. Long-term data collection supports evidence-based adjustments to the regime. Almost all jurisdictions around the world have systems for reporting on people requesting and having assisted deaths. However, there's a high degree of variability in the data reported around the world, and very few data items that are published consistently in all jurisdictions. We have an opportunity to learn from monitoring and reporting systems elsewhere and put in place the most robust system possible. Recent research published in the BMJ Supportive and Palliative Care in 2022 examined in depth the data reported in jurisdictions around the world. It identified official data reports from 16 jurisdictions where assisted suicide or euthanasia is legal. The research found that while most jurisdictions report the number of patients who die by assisted dying, only 3, and the research was done in 2022, so it is possible that there are now a few more, New Zealand, Canada and the state of Victoria in Australia, document the number of patients who make a request to die by assisted dying. Unless we know about the applications that are assessed as ineligible, we will not have adequate insight into the functioning of patient safeguards and eligibility criteria. This is a point that Dr. Annabelle Price made in oral evidence and in an editorial in the BMJ in 2015. We need to understand not just who has an assisted death, but who is deemed ineligible and why, to understand how the safeguards are functioning. The 2022 paper identified Colorado, Hawaii and Maine as reporting the number of patients who received assisted suicide prescriptions, but not the number of persons who actually die by their ingestion. In these jurisdictions, there is no record of how many of these patients ingested the prescribed drugs. This is stipulated in the Colorado End-of-Life Options Act 2021 data summary, which states that the Act does not authorise or require the Colorado Department of Public Health and Environment to follow up with physicians who prescribe aid-in-dying medication, patients or their families to obtain information about the use of aid-in-dying medication. The official statistics reported, therefore, reflect all deaths identified among individuals by prescribed aid-in-dying medication, irrespective of whether their death was caused by ingestion of medication, the underlying terminal illness or condition, or some other cause. So these states do not appear to have a mechanism to ascertain the amount of unused assisted suicide drugs circulating within the community. Now, while the fate of many therapeutic drugs with the potential for abuse or use for fatal overdose is not monitored, e.g. diazepam or morphine, the doses and combinations of lethal drugs used in assisted suicide and euthanasia may present a heightened risk. So monitoring the fate of these drugs should be considered. Concern around pressure on vulnerable groups warrants the detailed reporting of patient demographics. This is needed to ensure patient safety because it allows researchers and monitoring organisations to monitor trends to determine whether there is disproportionate participation by vulnerable or minority groups and the reasons for their participation. Even basic patient characteristics, including gender, age and ethnicity, are not universally reported in other jurisdictions. Although marital status could be an indicator of at-home support, fewer than half of reports include this. The level of education can be an indicator of socio-economic position, but is not routinely reported by many jurisdictions. Although we've been told that studies that have analysed routine statistics did not indicate a disproportionate use by lower socio-economic groups, socio-economic trends have changed over time and new evidence has emerged. For example, in Oregon, the proportion of assisted dying patients on state health aid has doubled in the last decade, reaching 79% in 2021. This indicates an increase in use over time by those of a lower socio-economic position. Similarly, an in-depth review by Ontario's coroner last year showed that those dying by their assisted death legislation, both Track 1 and Track 2, were more likely to be in those with longer prognoses. Given the impossibility of prognostication and the pressure being brought to bear by some campaign groups that this legislation before us should be wider, socio-economic data will be very important to ascertain whether there's equity and access to assisted dying and whether financial pressures, including access to benefits, are involved in areas of higher or lower uptake. Knowing whether patients have received care from hospice or palliative care services provides an understanding of whether patients have been provided with alternative end-of-life care options. This information is included in fewer than one-half of the reports from jurisdictions around the world, with none providing information on the duration or scope of hospice or palliative care involvement. For example, while official reports indicate that 80 to 90% of Canadian assisted deaths receive palliative care, other studies have shown that fewer than half of such patients had seen a specialist palliative care team. It's also essential to have information about the clinicians who participate in assisted dying. This information is important because the clinical demand for assisted suicide and euthanasia is highly time-consuming, with evidence from other jurisdictions, an Australia study of those participating clinicians, showing it takes 60-plus hours of work per assisted death. Understanding the number of clinicians participating in assisted dying and their specialty is important to understanding both the willingness of clinicians to participate as well as how the clinical demand for assisted dying is being distributed across specialities and practitioners. Information on the drugs used in assisted deaths is critical in order to understand safety and efficacy of different drugs and drug combinations. The 2022 paper found that just 6 jurisdictions report the drugs used to bring about patient death. There is no one drug or drug combination that has been shown to be most effective and safe for ending patients' lives. Indeed, if this research existed, then we would not see such variation in the drugs used. Data on complications following drug ingestion or administration is needed to understand the safety of different drug combinations, but it is rarely reported. Even in jurisdictions where information on safety is included, missing data can be high. For example, in Oregon, data on complications is unknown in up to 70% of cases annually. Reporting the drugs used to bring about patient death as well as information about the assisted dying process, including the time from drug ingestion or administration to patient unconsciousness and death and the presence of complications, would enable the safety and efficacy of these drugs to be assessed. Like many jurisdictions around the world, what is proposed in this amendment relies on retrospective reporting of data after the patient has died. I suggest that this is the minimum standard that must be achieved. Ideally, we would also build in processes for prospective scrutiny before the person has died, as well as formal review processes that scrutinise individual cases in more detail. It is of note that analyses from Belgium and the Netherlands, where review processes are established, have shown that 48% of assisted deaths in Belgium and 1 in 5 of such deaths in the Netherlands are not reported via the official reporting system, and in some cases legal requirements are not followed. Setting up a post-event review panel, such as happens in the Netherlands and Ontario, would also improve understanding and safety. In the Netherlands, every case is reviewed by a panel, and many cases, especially the controversial ones, are published to promote education and debate. Controversial or worrying cases will occur in England and Wales if this law passes, and it is essential for ongoing patient safety that these are not swept under the carpet, but that there are transparent processes to understand and learn from them. We frequently hear in this debate that there's no evidence of harm from other jurisdictions, but we have also heard powerfully argued that other jurisdictions do not collect the data we would need to determine this. In Oregon, information on complications following ingestion of lethal substances is missing in around 70% of cases. Robert Clark, the former Attorney General for Victoria, has written, "The Victorian oversight and accountability structure can best be described as one of hear no evil, see no evil, speak no evil. In other words, it appears designed for the regulator to find out nothing, investigate nothing, and report nothing that could suggest that assisted dying has been anything other than an unblemished success. Let us not repeat these mistakes. We can lead the way in terms of rigorous, comprehensive data collection and transparent monitoring." Amendments tabled by the member in charge changed responsibility for oversight from the Secretary of State and Chief Medical Officers to the Commissioner. This brings a danger of bias in reporting, as there could be an element of marking one's own homework. This means there's even more reason for complete data reporting and transparency. Ensuring that data collected is comprehensive and reporting is transparent may go some way to assuage this concern. Importantly, strengthening data collection, reporting and monitoring will not make the process harder or more lengthy for the person requesting an assisted death. It just makes the system safer and stronger. In this amendment, I'm not proposing doing anything new or radical. We are simply taking the strongest aspects of what is done in other jurisdictions and bringing them together to enable the best and most comprehensive reporting in the world. All new laws have risks as well as benefit. We must identify and be open about those risks in order to learn from harms and improve onward safety. This amendment will help us to achieve that. Thank you, Chair.
No, Sean.
Thank you, Chair. I'd like to speak to Amendment 455 and 456, all moved by the bill's sponsor. They concern the annual report that in the bill, as originally written, would be issued by the Chief Medical Officers for England and Wales. Now, if the other amendments pass, that report will be issued by the Voluntary Assisted Dying Commissioner. Amendment 455 does two things, broadly speaking. In subsection 2A, it says the Commissioner's report must include information about the application of the Act in relation to persons with protected characteristics. Amendment 456 clarifies that this definition of protected characteristics is the same as that used in the Equalities Act 2010. Subsection 2A also says the Commissioner must also report on any other description of persons specified in regulations made by the Secretary of State. Subsection 2B of the amendment says that when the Commissioner is preparing their report, they must consult with the Chief Medical Officers for England and Wales. The Commissioner must consult with such persons appearing to the Commissioner to represent the interests of persons who have protected characteristics as the Commissioner considers appropriate. I will come back to the part of the amendment that talks about the need to consult with CMOs later. Let me talk first about how Amendment 455 deals with the reporting on people with protected characteristics. I welcome that change as far as it goes. Several witnesses who have spoken or written evidence or provided written evidence have warned that assisted dying could have a harmful impact on women or people from ethnic minorities or on the disabled. Others have warned that it could have a harmful impact on people from low-income backgrounds or economically disadvantaged areas. Amendment 455's duty for the Commissioner to report on people with protected characteristics would mean that officials were looking at outcomes for some of these groups. As honourable members will know, the Equality Act specifies 9 protected characteristics, including age, disability, race, religion or belief, sexual orientation and sex. This part of the amendment shows that the bill's sponsor recognises that assisted dying could have an adverse effect on some of those groups. Unfortunately, these amendments do not impose a duty on the Commissioner to report on the bill's impact on people with low incomes or from economically disadvantaged areas. I regret that the committee has rejected several amendments that would have imposed the duty on officials to report on these groups. I also agree with the intention behind subsection 2B of Amendment 455 that says the Commissioner must consult with people representing groups with protected characteristics. Again, it is welcome that my honourable friend sees that the annual reports will need to take particular account of how assisted dying affects potentially vulnerable people. But like so much in this bill, I think it gives the Commissioner too much leeway to decide who does represent these groups. It would surely be better to give the Secretary of State the ability to specify representatives in regulations. Taking that route would allow Parliament to have oversight on which groups the Commissioner spoke to. I understand that a new clause tabled by my honourable friend for Penstone and Stockbridge proposes to set up a group that would advise the Commissioner on how assisted dying affects disabled people. I welcome that proposal, but I will also note that this leaves the Commissioner with the power to decide who they will speak to about other groups with protected characteristics. That will mean it's on the Commissioner's say-so who they speak to representing the interests of, say, women or of ethnic minority groups or of older people. The Commissioner might choose representatives who will ask difficult, well-informed questions, or they might not. As I've said before, we all suffer from conscious bias. One of the biases we all have, is that we look for evidence of what we have done is right and that what we believe is correct. Psychologists have given this the name of confirmation bias, and I think we can all remember seeing it in our own lives. So I don't think it's a sensible approach to ask an official who runs the system to find people who will tell them if that system might be going wrong. Let me now look to Amendment 455, which deals with the Chief Medical Officers for England and Wales. Previously, Clause 34 gave the CMO the responsibility for monitoring, inspecting and reporting on the assisted dying system. But this amendment says only that the Commissioner must consult the Chief Medical Officers when preparing an annual report. That amendment leaves an awful lot to the Commissioner's discretion. It doesn't say on what matters, it doesn't say how detailed this consultation should be, and it doesn't say what should happen if the CMO thinks something is worthy of investigation, but the Commissioner disagrees. All in all, the references to the Chief Medical Officers in these amendments seem to me a box-ticking exercise. The involvement of the CMO would lead to detailed investigation of aspects of the assisted dying system, or there could be a brief consultation. Of course, the CMOs are very senior doctors and experienced public servants of very high quality. I am confident they will always strive to do the right thing, and I am confident the Commissioner will be a senior legal figure with great integrity and knowledge of the law. But this bill is completely vague about how the CMO should get involved in the Commissioner's report. I've worked in the NHS, and most employees I met were highly motivated public servants. But as I say, most NHS people would always try to do the right thing. Here's an important thing that I've learned. When people are in complex situations, when they have many tasks and not much time to do them, they need clearer guidance. And this amendment does not give us that. I think that CMOs should be the main officials reporting on the assisted dying system, as I have said repeatedly today. And it's a very important point. But since the bill sponsor is putting forward amendments which mean only that the CMOs should be consulted over the Commissioner's report, we need clarity on what that should mean, but this amendment doesn't unfortunately give it. Amendment 455 and 456 would leave us with a much weaker system of monitoring and reporting than the bill is originally written, which is why I don't support it, and I hope other members will also reject it. Thank you, Chair.
Minister.
Thank you, Sir Roger, and it's a pleasure to serve under your chairship. Amendments 450 and 451. I'll turn first to the lead amendment, Amendment 450, in the name of the member for York Central. As Clause 34 currently stands, the CMO, the Chief Medical Officer, must submit an annual report on the operation of the Act. Under amendments tabled by the sponsor, this would be the responsibility of the Commissioner. The amendment requires the Chief Medical Officer to annually produce an equality impact assessment which assesses access to both assisted dying and to palliative care for those with protected characteristics and by socio-economic status and geographical location. This amendment seems intended to ensure that monitoring and reporting considers the impact of the bill on vulnerable groups. Protected characteristics are defined by reference to Section 4 of the Equality Act 2010, which means that the report would need to consider the characteristics of age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex and sexual orientation. The term equality impact assessment is not defined in the amendment or elsewhere in the bill. And whilst equality impact assessments are produced routinely by government and other public bodies in order to discharge the public sector equality duty, it's not clear what type of assessment this amendment is requiring. And so there may be difficulties in practice for the Chief Medical Officer in understanding whether the duty has been discharged. Impact assessments are not within the purview of a Chief Medical Officer and should be undertaken by those who are appropriately qualified to carry them out. In addition, socio-economic status and geographical location are also undefined in the amendment and are not defined elsewhere in the bill. Socio-economic status and geographical location are not of themselves protected characteristics under the Equality Act, and so are not required to be considered as part of the public sector equality duty. It's not clear, therefore, what the assessment of those factors is intended to involve. I will give way.
I thank the Minister for giving way on that. Whilst I appreciate it's not necessarily a duty as defined in law, but given the way our government certainly operates, we need that. Does she not agree that we need that data to inform us to better services elsewhere as well? So we could apply that to this bill as well.
Minister.
It's right that the Commissioner, in their role in scrutinising the operation and the workability of the assisted dying regime, could, under the powers conferred by the draft bill, look at a range of factors and indeed look at whatever they deem relevant to discharging that exercise. The question is what is appropriate to be defined within primary legislation, and the government's position is, given that as a public body it would be governed, as all public bodies are, by the Equalities Act. That would include due regard to all those characteristics, protected characteristics, but what is not defined within the amendment that we're considering is socio-economic position or geographic location. If those were things that down the line it was determined that the Commission wanted to look at, they could look at it. Yeah, of course.
I thank you, Mr. Giveaway. So from a public health perspective, there's a huge debate going on we've had for weeks and weeks now, whether this is a health intervention, whether it's not a health intervention, whether it's going to be provided by the NHS, whether it's going to be provided elsewhere. But from a public health perspective, we, as a Public Health Reform Commissioner, we collected both socio-economic data to influence how to learn about not just protected characteristics, but those socio-economic backgrounds, because some of the concerns are about those who are disadvantaged groups, that they are more vulnerable, and they have. So that, would it not be appropriate to have this on the face of a bill to address some of those safeguard issues?
Minister.
I would suggest that these are ultimately policy choices, first for the sponsor, and then later, if the regime is voted on and passed, for the Commissioner. In reality, a lot of the data one is going to be collecting when one has due regard to the impact and the differential impact on these protected groups, it's actually going to have a large degree of overlap in practice, as so often is the case in equality impact assessments, with other aspects of socio-economic disadvantage.
Minister, give way.
I'm happy to give way.
I'm grateful to the Minister. I had an interesting exchange with a member for Penistone and Stocksbridge last week when we talked about socio-economic indicators, and they are in the Equality Act, but they've not yet been implemented. I understand it's in the Labour Party manifesto in 2024 that the government will be bringing forward the implementation of socio-economic factors that are on the face of the Equality Act. And given, as I understand it, that the implementation of this bill is now going to take us probably up to the next general election, does the Minister not think that at some point before this bill is fully implemented there will be a way of collecting the relevant socio-economic statistics?
Minister.
The Honourable Member is absolutely right. Section 1 of the Equality Act 2010 refers to having taking into account when making public decisions and administration of the impact that that has on socio-economic disadvantage. That was something that the previous Labour government brought in with its landmark Equality Act 2010, but it was never brought into force. And it is something that she's absolutely right, again, that this government is looking to do. The question is, what is appropriate to be done on the face of this act that we're considering right here, right now? And what I am saying is, from the government's point of view, the Voluntary Assisted Dying Commission will be subject to the Equality Act, such as it stands, and it's right that there is no need to specify on the face of the Act the conduct, the carrying out of an equality impact assessment, and whatever that contains at the appropriate time will contain whatever the Equality Act requires of that public decision maker. So I don't think we need to preempt things that haven't yet happened in other areas of legislation through this vehicle. The other point is, as I said, leaving over for regulations and guidance that it's anticipated that the Voluntary Assisted Dying Commission will produce, taking into account what needs to be taken into account in order to fully understand what the regime and how it's operating, what needs to be taken into account. All of that can be developed by what will ultimately be an expert body in this field should Parliament decide to vote on it. In this context, and considering these amendments, is what do we as a committee, and what does Parliament say needs to go on the face of the bill right now? And the government's position is that these amendments are neither necessary nor workable within our current legal regime. Amendment 451 seeks to further specify what is included within the Commissioner's annual report under the sponsor's amendment to Clause 34. Under Amendment 451, this report must contain information on where there have been complications in the procedure. And we assume, and I think this was clarified earlier by the member for Bradford West, this to mean the procedure relating to the self-administration of the approved substance, and she referred to Clause 9 in that regard. The Commissioner's report would also be required to include analysis of a specified list of matters, including the diagnosis and prognosis of persons seeking assistance, concerns raised by family members or the multidisciplinary panel, and demographic data, including socioeconomic data and information on protected characteristics. Amendments 455 and 456. The Government has worked with the bill's sponsor on these amendments. Under the sponsor's amendments 455, the Commissioner's annual report would be required to include information about the application of the bill to persons with protected characteristics and any other descriptions of persons specified in regulations made by the Secretary of State. So that's the point, that this regime can evolve as appropriate when we know what it looks like and how it's operating. We can even go further than some of the categories that some members have described. This may include persons from different demographics and socioeconomic backgrounds as proposed by this amendment. Amendment 455 would also require the Commissioner to consult, when preparing an annual report, with the Chief Medical Officer for England, the Chief Medical Officer for Wales, and other persons which appear to the Commissioner to represent the interests of persons who have protected characteristics and which the Commissioner deems appropriate. Amendment 456 flows from Amendment 455 and inserts into Clause 34 that the term protected characteristics has the same meaning as in Section 4 of Part 2 of the Equality Act 2010. And whilst some members of the committee have challenged or criticised the sponsor's choice, and it is a matter for the sponsor so far as the government's concerned, to substitute the Chief Medical Officer for the, the other way around, substitute the Voluntary Assisted Dying Commissioner for the Chief Medical Officer in carrying out this consultation, in carrying out this monitoring function. I would say, as Minister of State for the Ministry of Justice, that when one has a judicial figure in the role as Commissioner, even if that person is a retired judge, they are subject to the guide and the ethical code of judicial conduct, one of impartiality and independence, to conduct themselves appropriately. And I think the committee would do well not to impugn that impartiality. New Clause 33 and New Schedule 3. Chair, I finally turn to New Clause 33 and New Schedule 3 in the name of the member for Richmond Park. New Clause 33 and New Schedule 3 seek, as we've heard, to specify statistics which the Voluntary Assisted Dying Commissioner must collect and publish within an annual report. the Secretary of State would have the power to vary the contents of the schedule by regulation. As I stated earlier, the sponsors' Amendment 382 would require that the functions under current Clause 34 are carried out by the Commissioner as opposed to the Chief Medical Officers for England and Wales. These functions include submitting an annual report on the operation of the Act, which could already encompass the information set out in this amendment. Under the sponsors' Amendment 455, the report must also include information, as we've heard, about the application of the bill to persons with protected characteristics and other persons specified in the regulations. Therefore, the changed approach from the sponsor would seem, from the government's point of view, to accomplish much of what the member is seeking to do. That's all I propose to say, as I hope that's been of assistance to the committee.
Kim Leonard.
Thank you, Sir Roger, and it's a pleasure to serve under you this evening. At the risk of repeating what's already been said before by various members of the committee, Amendments 455 and 456 are important amendments which further strengthen the oversight and transparency and the implementation of the bill, particularly in relation to protected characteristics. Clause 34 subsection 1 already establishes the requirement of an annual report to be produced, but Amendment 455 goes further by mandating that this report must also include detailed information about how the Act applies to individuals with protected characteristics. These are the groups identified in the Equality Act 2010, such as age, disability, gender reassignment, race, religion and others. Furthermore, this amendment ensures that the report will not only cover these protected characteristics, but also any other group that may be specified in regulations set by the Secretary of State. This provides the flexibility to adapt and ensure that the Act is applied fairly to all groups as societal needs and considerations evolve. Amendment 455 also ensures that the Commissioner consults relevant stakeholders when preparing this annual report. Specifically, the Chief Medical Officers for both England and Wales will be consulted, along with representatives of groups advocating for those with protected characteristics. This collaborative approach ensures that the report is as comprehensive as possible. Of course, this report would also be supported by additional details and regulations, and the doctor's reports, of course, and the review of the Act as set out in Clause 35. And as such, Chair, I'm confident that the reporting mechanisms as set up under these amendments provide a thorough oversight for the assisted dying process.
Now, Shah, to wind up the debate. Amendment 450 to Clause 34, as on the order paper. Question is that the amendment be made. As many of that opinion say aye. Contrary, no. The noes have it. Amendment 387 to Clause 34, which has already been debated with Amendment 382. Kim Ledby to move formally.
Move formally, Chair.
The question is that Amendment 387 to Clause 34, as on the order paper, be made. As many of that opinion say aye. Aye. Contrary, no. The ayes have it. Amendment 220 to Clause 34, which has already been debated with Amendment 184. Kim Ledby to move formally.
Move formally, Chair.
The question is the amendment be made. As many of that opinion say aye.
Aye.
Contrary, no. The ayes have it. Amendment 388 to Clause 34, which has already been debated with Clause 12 stand part. Kim Ledby to move the amendment formally.
Move formally, Chair.
The question is that amendment be made. As many of that opinion say aye.
Aye.
Contrary, no. The ayes have it. Bear with me. Amendment 451 to Clause 34, which has already been debated with Amendment 450. Does anybody wish to move that amendment formally? Not moved. 451. No. Not moved.
Sorry, I move that.
You want to move it?
Yes, please.
Right. The question is that Amendment 451 to Clause 34, already debated with Amendment 450, be made. As many of that opinion say aye.
Aye.
Contrary, no.
No.
Division.
Division is moved.
Lock the doors.
Jack Abbott.
No.
Lewis Atkinson.
No.
Juliet Campbell.
Aye.
Bambos Charalambos.
No.
Daniel Francis.
Aye.
Tom Gordon.
No.
Sarah Green.
No.
Rachel Hopkins.
No.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Ledbeater.
No.
Kip Malthouse. No. Sarah Olney. Aye. Dr. Simon Ophir. No. Rebecca Paul. Aye. Jake Richards. No. Sarah Sackman.
No.
Liz Saville-Roberts. Naz Shah.
Aye.
Dr. Neil Shastri-Hurst.
No.
Dr. Marie Tidball.
No.
Sean Woodcock.
Aye.
Thank you. The ayes were 7, the noes were 15, so the noes have it. Unlock. Now come to Amendment 455 to Clause 34, which has already been debated with Amendment 450. Kim Leadbeater to move the amendment formally.
Move formally, Chair.
The question is that Amendment 455 for Clause 34, as on the order paper, be made. As many of that opinion say aye.
Aye.
Contrary, no. The ayes have it. We now come to Amendment 274 to Clause 34, which has already been debated with Amendment 273. Ms Olney, do you wish to move the amendment formally? The question is that Amendment 274 to Clause 34, as on the order paper, be made. As many of that opinion say aye.
Aye.
Contrary, no.
No.
Division. Lock the door.
Vision in room 10.
Jack Abbott. No. Lewis Atkinson.
No.
Juliette Campbell. No. Bambos Charlambos.
No.
Daniel Francis. No. Tom Gordon.
No.
Sarah Green. No. Rachel Hopkins.
No.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kip Malthouse.
No.
Sarah Olney.
Aye.
Dr. Simon Ophir.
No.
Rebecca Paul.
Aye.
Jake Richards.
No.
Sarah Sackman.
No.
Liz Saville-Roberts. No. Naz Shah. Dr. Neil Shastri-Hurst.
No.
Dr. Marie Tidball.
No.
Sean Woodcock.
No.
The ayes were 4, the noes were 18, so the noes have it. Unlock. We now come to Amendment 389 to Clause 34, which has already been debated with 382. Kim Leadbeater to move formally.
Move formally, Chair.
The question is that Amendment 389 to Clause 34, as on the order paper, be made. As many of that opinion say aye. Aye. Contrary, no. The ayes have it. Amendment 456 to Clause 34, which has already been debated with Amendment 450. Kim Leadbeater to move formally.
Move formally, Chair.
Amendment 456 to Clause 34, as on the order paper. The question is that amendment be made. As many of that opinion say aye.
Aye.
Contrary, no. The ayes have it. We now come to the question that Clause 34, as amended, stand part of the bill. I understand that this clause has been pretty thoroughly debated, so I don't propose to permit a stand part debate. So the question is that Clause 34, as amended, stand part of the bill. As many of that opinion say aye.
Aye.
Contrary, no. The ayes have it. Ms Saville-Roberts, I'm told that you don't wish to move Amendment 161, is that correct? That's correct. Okay. That's fine, thank you. So, Clause 35. We now come to Amendment 452 to Clause 35 in the name of Rachel Maskell, with which it will be convenient to consider Amendments 493, 453, 494, 495 and 526. Does anybody wish to move Amendment 452? Now, Shah.
Thank you, Chair. I'd like to move Amendment 452, tabled by my honourable friend for York Central. Under the bill, as presented at second reading, the Secretary of State would have to report to Parliament on how the assisted dying system was functioning, but the Secretary of State would only do so after that system had been in operation for 5 years. Under my honourable friend's amendment, the Secretary of State would have a requirement to report annually on how the system was working. I find the provision in the original bill for a 5-yearly report to be extremely surprising. The requirement on the Secretary of State to report to Parliament is a major safeguard. It will prompt the Secretary and their State and their officials to probe all the available data on the system. And it will also allow members of this House and the other place to go over that information and look for problems should they arise and ways to resolve them. This could be one of the ways in which we identify failings in the system early, given that we are discussing a system to allow people to take lethal drugs. That is surely what we should be aiming for. We cannot afford to wait through years of media reports and complaints before having to investigate alleged problems. If this amendment is accepted, then it is not certain that the Secretary of State's report and the scrutiny of Parliament will identify problems in a timely way, but it does increase that possibility. If we have to wait 5 years for such report, it is much less likely that we will spot any problems before they have had terrible consequences. I urge honourable members to vote for this amendment. This amendment would replace a 5-yearly report as envisaged. Thank you, Chair.
Amendment 452 to clause 35, as on the order paper. The question is the amendment been made. Danny Kruger.
Thanks, Sir Roger. So very quickly, I very much concur with the points made by the Honourable Lady. But just to add, I do very much appreciate the presence of this clause in the bill. I think it is very helpful that we are ensuring that there will be proper review. But as the Honourable Lady said, it does feel too long to wait for 5 years. So I support the amendment in the name of the member for York Central, also that the member for Bexley Heath and Crayford, who suggested a 3-year review period. My simple further point to make is that this is threshold legislation that we are potentially creating here. Once we take the step down this road, there is no going back, and the bill leaves so much open for further, I suggest, expansion, but certainly modification and obviously clarification of the operation of the Act. And there is a lot for ministerial discretion, a lot for guidance and codes of practice, as we've debated so far as we go through the bill. Indeed, new powers have been added, a widening of the Henry VIII power. So I think it is very important that we bring the review period forward. Also, as my Amendment 526 suggests, I think it's not sufficient simply to undertake a review, even one that is annual or every 3 years. There must be a guaranteed right to a debate and for ministers to be held for account at the dispatch box, which my amendment would insist on. And lastly, to the point of the inherent potential for expansion due to the wide discretion that the bill still allows for future ministers, my concern actually is that the review itself might become a Trojan horse for further expansion, because this is what we see in other countries. It's held out as a safeguard, and indeed that's exactly how we should regard it, and I hope it will be that. It will enable us to check very thoroughly if there is a proper debate, proper ministerial accountability. It will enable Parliament to keep the operation of the bill under very close scrutiny. The danger is, though, as we've heard from Australian and American practitioners, that the reviews that are undertaken in other jurisdictions are actually used to unpick safeguards, because these safeguards become reframed as barriers to access, which is indeed implicit in a bill which creates a new human right. The safeguards that are created discriminate against certain groups of people, those who have a diagnosis of more than 6 months, for instance, most obviously, or those who have to go through the hoops set by the bill in terms of the numbers of assessments, and or those for whom the doctor wasn't able to make the suggestion directly to them, although we do have that in this bill. So the safeguards that will be in the bill, weak as they are in my view, nevertheless might be challenged in the course of the review. So if that's what happens, that's what happens. But it's all the more reason why I think it's very important that we do insist on both regular and quite short-term reviews, but also that Parliament itself should have a meaningful debate with ministers answering for the operation of the Act. Thank you.
Daniel Francis.
Thanks, Sir Roger, and it's a pleasure to serve under your chairship. So it's been a long process, of course, which we're not near at the end of now. But members will recall at the start of the process, I was very insistent that MenCap gave oral evidence to us. And when they did give us that oral evidence, Dan Scorer from MenCap, and I quote, said to us, clause 35 is about the review of the Act. The lived experience of people is absolutely vital to that. The bill says that it will be 5 years until we have that review. Our view is that it is far too long. If the bill becomes law, and if there are really serious issues and discrimination taking place against people, we will want to know that a lot earlier than in 5 years' time, and we will want action to be taken. Our suggestion is that review should be earlier. We would want to see strong representation from patient groups across that, as well as from people who have been involved in the process, such as family members, advocates and clinicians.
We're doing all in a good way.
Absolutely.
I'm very grateful to the honourable member who's, as ever, raising really important points. But is he reassured by the fact that the Commissioner will be reporting on an annual basis, as per the previous clause, as well as the panel giving reasons in public, for which were likely to be public as well? Does that give him any reassurance on this really important point?
Thank you, Chair. Yeah, the annual reporting does give us reassurance, of course, but clearly some reassurance. But, you know, as I've said, you know, the position of MenCap at the outset, and of course we accepted some of MenCap's recommendations last week, and I said on that occasion when we accepted those recommendations that, you know, I would welcome accepting all their recommendations, and their recommendations in their entirety was for that overall review at an early stage of the process. So I'll continue the quote from them, which was that those involved in the process, such as family members, advocates and clinicians, to make sure that if serious issues are being raised, they can be picked up early and addressed. So hear what my friend has said, but therefore, Chair, amendments 493, 494 and 495, standing my name on that basis because of those concerns, and clearly a consistent concern of mine, is how we would address issues if from specific communities, particularly for those with learning disabilities, were come to light, how we would address those and look at amending that legislation at a reasonable stage in the process. And that's why those amendments stand in my name, which I will beg to move in due course. Thank you, Chair.
Lewis Atkinson.
Thank you, Sir Roger. It's a pleasure to serve under you this evening. I'll just speak briefly. I'm in favour of retaining the bill as it stands. And I think the key thing here is the interplay between this clause and clause 42 in terms of commencement. So I absolutely accept, and I would have been minded myself to support changes in the reporting period had the bill been commencing within 2 years as immediately drafting. But the Honourable Lady clearly will debate it in due course has moved an amendment to change the backstop of the commencement period to 4 years. So actually, remember, the time scales set out under this clause are from the passage of the Act. It makes no sense to carry out a review of the operation, a formal review of the operation of the Act before the services have come into being. So a 4-year timetable potentially in terms of backstop commencement. Throughout that time, the Commissioner, assuming they will have been appointed undoubtedly in advance of that time, their annual reporting requirement will kick in. I would also draw the committee's attention to the new clause moved by my honourable friend, the member for Penistone and Stocksbridge, around new clause 35. And I think that in particular speaks to some of the concerns raised by the member for Bexley-Heath and Crawford. In terms of that amendment, I will be supporting very strongly the establishment of a disability advisory group, not just to report on the effect of the Act on an annual basis around disabled people, but also the implementation. So absolutely picking up any concerns or any views in terms of the Act's effect on people with disabilities will happen in a timely manner under new clause 35. So it's right. Yes, of course I will.
Thank you, Chair. He's making a really important point, which I will come on to myself in due course. But the thing that we need to analyse is the operation of the Act. And that doesn't start with the passing of the Act, it starts with the commencement of the Act. So it's important that we join the dots between the relevant clauses.
Lewis Atkins.
I think that's exactly right. So, for those reasons, I will think we need to retain the formal review period of the Act by the Secretary of State at a 5-year period, as the Honourable Gentleman from Rother Valley's outlined. That will all be in addition to the annual reporting from the Commissioner. It would be in addition to, if we pass new clause 35, annual reports from the Disability Advisory Council. So I think actually over the course of those multiple amendments, it's clear that we have strengthened the reporting requirements both in advance of implementation and post-implementation as well. Thank you, Chair.
Minister.
Thank you very much, Sir Roger, and it's a pleasure to serve under your chairship this evening. Amendments 452 and 453 seek to amend the current review provisions in clause 35 of the bill. As the bill currently stands, clause 35 subsection 1 provides that the Secretary of State must undertake a review of the operation of the bill and lay a report before Parliament. This is a one-off obligation which must take place after a period of 5 years beginning from the date the bill is passed. Amendment 452 seeks to amend this requirement and instead requires the Secretary of State to undertake a review, prepare and publish a report every 12 months after the passing of the bill. Amendment 453 removes the definition of the initial 5-year period and is consequential to Amendment 452. This increased frequency in reporting would naturally increase the administrative burden and cost of the bill. It is also noted that there will be an implementation period following royal assent. It is unclear if the intention is to require the Secretary of State to undertake a review of the operation of the bill and prepare a report during this implementation period.
I thank the Minister for giving way on that, and I'm rather surprised by his assertion or his words with regards to the cost of the bill, because my understanding when we've debated cost is that if we pass this bill, if this bill is passed in this House, the cost is something that will be footed. So why is it a cost implication when it comes to this amendment and not other things?
I thank you for that intervention. I make these comments not with a value judgment. It's simply a statement of fact that an increase in the amount of reporting and the time that would take and the resource that would take would inevitably lead to a cost. I make no value judgment on that. I'm merely here to point out to the committee the government's view on all aspects of the technical implementation of the bill and the consequences of any changes that the committee may wish to make to the bill. Amendments 493, 494 and 495 would change the period after which a review of the bill is required from 5 years to 3 years. As mentioned previously, clause 35 provides that the Secretary of State must undertake a review of the operation of the bill and lay a report before Parliament within 12 months of the end of the 5-year period after the bill is passed. These proposed amendments would instead require the review of the operation of the bill, the preparation of the report and the laying of the report to take place within 12 months of the end of the 3-year period, which immediately follows the day on which the bill is passed.
Order. Division on the floor of the House. Sitting suspended until 7:20. Order. Order.
Roger, just picking up on Amendment 526, which would impose a duty on a minister to arrange for the report on the review of the operation of the bill to be debated by both the House of Commons and the House of Lords within 14 sitting days, beginning with the day after the laying of the report. This goes further than laying the report before Parliament as currently required under clause 35. I hope those observations were helpful. Thank you.
Thank you, Chair. Chair, I'll speak briefly to this clause because I think some of what I'm going to say will be covered in future clauses, but the title of the clause is Review of the Act. So I think it's important to be clear about what we are actually reviewing. And I'm sure members of the committee agree it's the operation of the Act that needs to be considered. And I suppose as such it's important to join the dots between the relevant clauses of the bill and differentiate between the passing of the Act and the commencement of its provision. I've tabled Amendment 548 in relation to clause 42, commencement of the Act, which provides that the commencement of the provisions of the Act could be up to 4 years, beginning with the day on which the bill is passed. I sincerely hope it's sooner than that, but I've tabled that amendment nonetheless. New clause 40 also provides that until the Act is implemented, the Secretary of State must lay a report before Parliament as soon as reasonably practical after the first anniversary of the Act being passed. So the subsequent reports will then be made every 6 months up to full implementation. So it's a very comprehensive reporting system, and I think it's really important to look at what we're reporting on, and the reality is the commencement of the Act could be between 2 and 4 years. So I think the 5-year review makes sense. Thank you, Chair.
That sounds lined up. No. Amendment 452 to clause 35 as on the order paper. The question is that amendment be made. As many of that opinion say aye. Contrary no? No. The noes have it. Amendment 493 to clause 35. Yes. Yes. Sorry. Amendment 493 to clause 35. Sorry. Which has already been debated with clause 452. It is very confusing. Mr. Francis, do you wish to move?
I beg to move, Sir Roger.
Amendment 493 to clause 35, which has already been debated with Amendment 452. The question is that that amendment be made. As many of that opinion say aye. Aye. Contrary no? No. Division.
Division in Room 10.
Lock the doors. I think leave them locked for the moment, please. Go ahead.
Jack Abbott.
Aye.
Lewis Atkinson.
No.
Yes. Juliet Campbell. Aye. Aye. Lambos, Chair Lambos.
No.
Daniel Francis.
Aye.
Tom Gordon.
No.
Sarah Green. No. Rachel Hopkins. No. Sojourn Joseph.
Aye.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kit Malthouse.
No.
Sarah Olney.
Aye.
Dr. Simon Ofer.
No.
Rebecca Paul.
Aye.
Jake Richards.
No.
Sarah Sagman.
No.
Liz Seville-Roberts.
No.
Naz Shah.
Aye.
Dr. Neil Shastry-Hurst.
No.
Dr. Marie Tidball.
No.
Sean Woodcock.
Aye.
The ayes were 9 and the noes were 14, so the noes have it. Bear with me. We now come to Amendment 493 to clause 35 in the name of Daniel Francis.
We don't need to do that one because
We don't. I beg your pardon. Sorry, this is interdependent, I think is the word. Ms Samuel-Roberts, do you wish to press your amendments to a division?
These, again, is one of the series that I have with.
Sorry, I can't hear. Amendment 162 to clause 35.
Withdrawn.
Which has already been debated with 144. You don't wish to press it?
No.
Thank you. We now come to 453 to clause 35, which has been debated with 452. Does any member wish to move the amendment formally? Not moved. Amendment 494 to clause 35, which has already been debated with 452. Mr. Francis? Oh, I beg your pardon. That's fallen as well.
It's fallen.
And that one's fallen as well.
It's fallen, has it?
Yeah, I'm afraid so. They're interdependent. So it's very confusing. I've been doing this quite a long time. Look, if I'm having a problem with it, anybody's going to have a problem with it. But it has fallen. I'm sorry. So we now come to clause 35, 491, in the name of Mr. Francis, with which it will be convenient to consider amendments 492 to 397. Daniel Francis to move amendment 491.
Thank you, Chair. I will be brief. Firstly, amendments 491 and 492, I know in the next group we'll also discuss new clause 28. All three of those clauses have been suggested by Marie Curie, the UK's leading end-of-life charity. I'll briefly speak about 491 and 492 now. So amendments 491 and 492 are minor amendments that would broaden the scope of the required assessment of the availability, quality and distribution of palliative care services to be undertaken as part of the 5-year review of the Act by referring to health and care services to persons with palliative and end-of-life care needs, providing a more holistic consideration of end-of-life care than the current drafting of health services for persons with palliative care needs, which would reflect the current clinical best practice of palliative care multidisciplinary teams incorporating both health and social care professionals. The explanatory notes again explain that's in line with current clinical best practice and is in line with the written evidence that Marie Curie has supplied to us. So I will be moving amendments 491 and 492 in my name. In addition, Amendment 397 on clause 35, page 22, is in line with many other amendments I've moved during this process and seeks for an assessment of the impact of the Act on persons with learning disabilities, including any concerns about the operations of the Act in relation to such persons. So I will, in due course, Chair, move the three amendments which sit in my name.
Amendment 491 to clause 35 as on the order paper. The question is, the amendment be made? Minister?
Thank you very much, Sir Roger. This group of amendments relates to clause 35 of the bill, which set out requirements for the review of the legislation. Amendments 491 and 492 aim to broaden the scope of the assessment criteria for the review of this Act. 491 expands the scope of the report the Secretary of State must prepare at the end of the initial 5-year period to include an assessment of the availability, quality and distribution of appropriate care services to persons with palliative care needs as well as health services. By inserting "and care," Amendment 491 would mean that both health and care services are assessed for people with palliative care needs. Care services play an important role in supporting terminally ill individuals with care needs in settings such as care homes and in the community. However, it is not clear what the term care services would cover. This could include, for example, unpaid care, private or local authority funded care, or non-statutory care services such as befriending. 492 extends into who the assessment will cover to include those receiving end-of-life care alongside those with palliative care needs. The committee may find it helpful to note that while palliative care focuses on improving quality of life for individuals with life-limiting illnesses at any stage, end-of-life care specifically addresses the needs of an individual in their final year. The committee may also find it helpful to note that, as amended by the committee, a person is considered terminally ill under the scope of the bill as outlined in clause 2, paragraph 1 if the person's death in consequence of an inevitably progressive illness or disease which cannot be reversed by treatment can reasonably be expected within 6 months. 397, clause 35, subsection 1 in the bill, as drafted, requires the Secretary of State to undertake a review of the operation of the Act, prepare a report on that review and publish and lay the report before Parliament. The Secretary of State is required to do this during the period of 12 months, beginning after the period of 5 years from the day on which this bill is passed. Clause 35, subsection 3, provides a non-exhaustive list of what the report must set out. Amendment 397 requires that the report includes an assessment of the impact of the legislation on people with learning disabilities, including any concerns about the operation of the Act in relation to them. The amendment does not include a definition of learning disabilities and so may introduce legal uncertainty as to what must be included in the report. However, I would note that there is an existing definition of learning disability in Section 1, subsection 4 of the Mental Health Act 1983, which could be considered and may mitigate this uncertainty if this amendment were to be passed. Thank you, Chair.
Jim Levy.
Thank you, Chair. Amendments 491 and 492 expand the scope of the report the Secretary of State must prepare at the end of the initial 5-year period to include an assessment of the availability, quality and distribution of appropriate services by including care services and end-of-life care. It's not clear what care services would cover, and I'm concerned about the broadness of this term and the lack of a clear definition. Therefore, I'm not minded to support 491, but Amendment 492 expands the population that the assessment will cover to include persons with end-of-life care needs alongside palliative care. This makes sense. It seems like a very sensible amendment given the purpose of the Act, and therefore I'm very happy to support this amendment. Amendment 397 and the reference to the consideration and the impact on people with learning disabilities. We've had this conversation several times with the Honourable Member for Bexley from Crayford, and as I've said previously, he makes a very valid point with particular reference to this cohort of people, and as such I'm minded to support that amendment. Thank you, Chair.
Daniel Francis.
Well, I beg to move the 3 amendments in my name, please, Chair.
Amendment 491 to clause 35 as on the order paper. The question is that amendment be made. As many of that opinion say aye. Aye. Contrary, no. No. Division.
Division in room 10.
Lock the doors.
Jack Abbott.
Aye.
Lewis Atkinson.
No.
Juliet Campbell.
Aye.
Bambles Cheryl Lambos.
No.
Daniel Francis.
Aye.
Tom Gordon.
No.
Sarah Green.
No.
Rachel Hopkins.
No.
Sir John Joseph.
Aye.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kit Malthouse.
No.
Sarah Orney.
Aye.
Dr Simon Ofer.
No.
Rebecca Paul.
Aye.
Jake Richards.
No.
Sarah Sackman.
No.
Liz Saville Roberts. Naz Shah.
Aye.
Dr Neil Shastry-Hurst.
No.
Dr Marie Tidball.
No.
Sean Woodcock.
Aye. I'm away. Keep it pronouncing.
The ayes were 9 and the noes were 14, so the noes have it. Keep the doors locked, please. We now come to Amendment 492 to Clause 35, which has already been debated with 491. Mr Francis, do you wish to move the amendment formally? Amendment 492 to Clause 35 as on the order paper. The question is that amendment be made. As many of that opinion say aye. Aye. Contrary, no. The ayes have it. Amendment 397 to Clause 35, which has already been debated with Amendment 491. Mr Francis, do you wish to move the amendment formally?
I beg to move, Sir Roger.
Amendment 397 to Clause 35, as on the order paper. The question is that amendment be made. As many of that opinion say aye. Aye. Contrary, no. Ayes have it. Miss Saville Roberts. 163 to Clause 35.
Once again, I'm serious and premature.
Thank you. Not moved. We now come to Amendment 526 to Clause 35, which has already been debated with Amendment 452. Mr Kruger, do you wish to move that amendment formally?
Withdraw.
Withdrawn. Amendment by leave withdrawn. We now come to the question that Clause 35 stand part of the bill, with which it will be convenient to consider. Amendment 546, new Clause 20, new Clause 28, and new Clause 40. The question is that Clause 35 stand part of the bill. Kim Leadbeater.
Thank you, Chair. I'll speak to my amendments, new Clause 40 and Amendment 546. The purpose of Amendment New Clause 40 is to establish a requirement for regular reports on the implementation of the Act until all provisions in the bill are fully implemented. This ensures continuous oversight and transparency regarding the progress of the Act's implementation. The effective amendment, New Clause 40, is to mandate the Secretary of State to prepare, publish and lay before Parliament a report on the implementation progress of the Act as soon as reasonably practical after each reporting period. The reports must include progress made during the reporting period in implementing the Act, the Secretary of State's plans for implementing the Act in future periods, including an expected timetable for further implementation, and the reporting periods are structured as follows. The first report must be issued 1 year after the Act is passed, and subsequent reports are due every 6 months. The sixth and final report marks the conclusion of the reporting period. This amendment is linked to Amendment 546, which ensures that New Clause 40 will be brought into force immediately upon the passing of the bill, making these reporting requirements active right from the start. This provision is crucial for maintaining accountability, ensuring that Parliament is regularly updated on the progress of the Act's implementation and that any necessary adjustments or future plans are communicated effectively. It provides a structured timeline to track the implementation of the Act until all provisions are fully operational.
Question is, Clause 35, as amended, stand part of the bill? Danny Francis.
Thank you, Sir Roger. I wish to speak to New Clause 28 in my name in this grouping. Again, this amendment is suggested by Marie Curie, the UK's leading end-of-life charity. Amendment New Clause 28 is more substantive than the two amendments with my name in the previous group, would require an additional assessment within 12 months of the Act passing, with the Secretary of State required to undertake an assessment of the extent to which the Act is on course to meet its aim of following adults who are terminally ill, subject to safeguards and protections, to request and be provided assistance to end their own lives. Crucially, this would also incorporate an assessment of the current state of health and care services to persons with palliative and end-of-life care needs, and the implications of this Act on those services, including the quality and distribution of palliative and end-of-life care services. The new clause seeks to mirror the requirement already included within Clause 35 for an assessment after 5 years of the bill passing, only within 12 months of assent of the bill in order to provide a benchmark against which that later assessment can be measured. There's been much discussion about the relationship between this bill and palliative and end-of-life care services, and above all, the intention behind this new clause is to ensure that outside the proceedings of this committee, and indeed the progress of the bill, that relationship is properly and thoughtfully considered by government. Because we've heard from a range of expert evidence throughout the committee stating that despite the very high quality of palliative and end-of-life care in this country and the phenomenal efforts of clinicians and organisations delivering it, access to this vital care is all too often inequitable and subject to a postcode lottery. And as Marie Curie has stated in both her written and oral evidence, if the fundamental aim of this bill is to offer terminally ill people choice at the end of life, then genuine choice cannot exist unless dying people are able to choose to receive high quality palliative and end-of-life care. And the sad reality is that in too many cases today, people are not able to make that choice. I think there will most likely be consensus amongst us that action is needed to fix end-of-life care to ensure that all dying people can have choice and dignity, even if we disagree on whether that should be most appropriately be achieved on the face of the bill or through other mechanisms. There's also been a great deal of debate and discussion around what the impact of introducing assisted dying on palliative care services might be, and indeed reference to what might have happened in other jurisdictions. But we should not leave this to chance or fool ourselves that improved access to palliative and end-of-life care would be an inevitability as a result of the debate or level of public interest around this bill. In requiring an immediate assessment of the state of health and care services available to persons with palliative and end-of-life care needs through New Clause 28, we can create a framework for accountability within this legislation and a firmer basis upon which future policy and spending decisions on palliative care can be made. It may be useful to recall that we've not had a national strategy for palliative and end-of-life care since 2008, and whilst I appreciate there are major policy milestones approaching, such as the 10-year health plan, which could help to address this, my hope would be that an assessment of the quality and availability of palliative and end-of-life care services undertaken as part of this bill can sit helpfully alongside other plans and strategies. In introducing the bill at second reading, my honourable friend, the member for Spen Valley, chose to highlight that she had included in the bill a requirement for the Secretary of State to report to the House on the availability, quality and distribution of palliative care. At this point, the bill only requires such an assessment after 5 years, so I hope she and other members will agree it would be beneficial to support this amendment so that such an assessment may be undertaken within 12 months in support of the ambition that we see improvements in palliative and end-of-life care. Thank you, Chair.
Thank you for Mr Francis. For the avoidance of confusion, one moment. You will understand that these new clauses will not be voted upon now. You will have the opportunity to move them formally later when we reach them at the appropriate time in the course of consideration. Dr. Over.
Thank you, Chair. I'd just like to say very briefly that I find that the delay of 4 years, which is what NC 40 would put in place with this bill, is excessive in terms of time taken and needed to deliver the requirements to start the bill in legal terms. And I would urge the committee to reduce that down at least to a period of 3 years. That would mean 4 6-month checks rather than 6. The reasons for this are that I believe that we've created a thorough bill which is ready to implement. I understand that there are some pressures on the Department of Health which will, and so I'm accepting a year's delay in this. My worry is if we have a 4-year delay, that might well take us past the next election, and it will become an issue within the election.
Will Honourable Friend give way?
Yes, certainly.
Clearly, thank you, Chair. Clearly, this amendment was tabled within the last week. So, just to ask my honourable friend, has he sought advice from the clerks? Because clearly, the only way we could now amend this is for a manuscript amendment, and I presume at this 11th hour that wouldn't be allowable. So, just to clarify the position.
I'm afraid I don't understand how we can change that. I just wanted to put on record that I felt that a 4-year delay was excessive. However, I have no further no further items to add to that, but I would be interested in the legal opinion of whether we can change it.
Doubt. I'll try that again. A manuscript amendment at this stage would not be accepted. Yes, Lewis Atkinson.
Thank you, Chair. I rise to speak in favour of the sponsoring members' new clause 40. I think, given the implementation period that we're talking about, absolutely that repeat and routine reporting to Parliament on progress is essential, especially for those who want to see this done absolutely safely and properly, but do nevertheless. There are people, some of whom have joined us in the public gallery in recent weeks, for whom this needs to be done with deliberate speed, without any compromise on the safety and thoroughness of implementation. I think new clause 40 achieves that, and I commend it. I have to say, in a different world, there would have been a way of us sort of compositing the new clause 28 with new clause 40, and I regret that. I don't think the two are compatible. Therefore, I do think the honourable member for Bexley Heath and Crowford makes good points around that earlier assessment around palliative care. I don't think that's something that divides the committee. Certainly, some amendments that many people have moved over the course of this have sought to improve and strengthen palliative care as part of a holistic package at the end of life. And I wonder whether that's something that at report stage I might be able to work with the honourable gentleman on, even if it's not possible for us to pass tonight. Thank you, Chair.
Minister.
Thank you very much. The Government has worked with the sponsor on Amendment 546 and new Clause 40, which are consequential and are linked to other amendments to Clause 42, which relates to commencement of this legislation. New Clause 40 would require the Secretary of State to prepare, publish and lay before Parliament a report about progress made towards implementing the Act, and the Secretary of State's plans for implementing in subsequent reporting periods. The reporting periods are 1 year after royal assent and every 6 months thereafter, until the 6th and final reporting period. 546 provides that new Clause 40 will come into force on the day the bill is passed. New clause 20 would introduce... I will give it.
I'm very grateful to the Minister, and I wonder if he'd entertain a suggestion. I think the extension to 4 years is going to cause some concern and questions in the House when it gets that report on third reading. And given that he's obviously committing to reporting on a 6-monthly basis, it would be helpful if the House had a broad plan against which the government was reporting on implementation. And I wonder if he thought it might be a good idea, our reporter at third reading, possibly to come forward with an outline timetable that may then have been worked up as part of the general assessment of the project.
Minister.
I thank him for that intervention. That does sound like a sensible approach. I mean, the new clause 40 does set out that the report about progress made towards implementing the Act. I think, if I've correctly understood what the Right Honourable Gentleman is saying, he's looking for more flesh on the bones in terms of what that plan should be and what it should look like.
I'm grateful for this. I think sorry, forgive me, it's getting late for me. Yeah. Essentially what I was trying to point out was that 4 years is obviously a backstop. Yeah. And it may well be that the government is able to deliver the service in advance of the 4-year deadline. And I guess what might be helpful at later stages of the bill, certainly in the Lords possibly, is that the government is able to give an indication at that stage of what it thinks the likely timeline might be. Admittedly, there's going to be flexibility in there, naturally, and that might assuage some of the concern that my honourable friend has raised, that 4 years is quite a long time. Obviously, the Commissioner is going to be appointed at the 12-month mark, and that may accelerate some of the work. But I think having an indication might be helpful for members, Sir Roger.
Minister.
I thank him for that intervention. I get what he's saying now, in essence, that there will be different parts of the implementation period that will be done at different times. Data may take so long, training may take so long, so I think what he's asking for is a sort of breakdown on which parts of this could be implemented in indicative timeline. Yes, I'm very happy to take that up with officials, and I will come back to him in short order on that. So, just going back to new clause 20, this is about introducing a requirement on the Secretary of State to lay an annual report in both Houses of Parliament on the impact of the bill. The report would include the effect of an assisted dying service on access to healthcare, palliative care and assisted dying, and an analysis in relation to people's socio-economic status and protected characteristics. This report would sit alongside the existing requirement in clause 35 for a report 5 years after the bill is passed. The new clause would require that the first annual report is laid before each House on their first sitting day after 1 calendar year from the passing of this Act. The committee may wish to note that, given the 12-month time frame, the reporting requirement may start before implementation is complete. Protected characteristics are defined in Section 4 of the Equality Act 2010. However, socio-economic status is undefined in the amendment and is not defined elsewhere in the bill. It is therefore not clear what the assessment of those factors is intended to involve, and it may be difficult in practice for the Secretary of State to determine whether they have fulfilled this duty. New clause 28 would introduce a legal requirement on the Secretary of State to undertake an assessment of the bill within 12 months of it being passed and to publish and lay a report of this assessment in both Houses of Parliament. The committee may wish to note that, given the 12-month time frame, the reporting requirement may start before implementation is complete. Under new clause 28, the assessment must cover the extent to which the bill is on course to meet its aims, the state of health and care services for persons receiving palliative and end-of-life care, and the implications of the bill on those services, any emerging concerns relating to the operation of the bill, and any steps the Secretary of State proposed to take in response to those concerns. This requirement is in addition to clause 35 of the bill, which requires a review by the Secretary of State at the end of the initial 5-year period after the bill is passed. This new requirement is wider in scope and would be required after 1 year. Palliative and end-of-life care services are broad, holistic services provided by a range of professionals and providers, generalist and specialist, across the NHS, social care and voluntary sector organisations. Therefore, measuring the provision is difficult, as relevant consultations and tasks are not always coded as palliative or end-of-life care. Commissioning and contracting processes do not consistently support data collection, with block contracts and grants commonplace. It is also practically difficult to identify the bill as the catalyst of the implications on these services over the specific period, as these services are affected by multiple factors. Thank you, Chair.
Kim Ledbetter.
I've got nothing further to add, Chair.
The question is that clause 35 stand part of the bill. As many of that opinion say aye? Aye. Contrary, no. The ayes have it. We now come to Amendment 454 to clause 36 in the name of Daniel Francis, with which it will be convenient to consider clause 36 stand part. Daniel Francis to move Amendment 454, please.
Thank you, Chair. Amendment 454 stands in my name on the clause relating to the disqualification from being a witness of proxy. So, clause 36, part 2, outlines the reasons why an individual can't be a witness of proxy if they're a relative of the person, if it's believed they're a beneficiary of the will, if they may otherwise benefit financially, if they're a health professional who's provided treatment or care for the person, or if they've not yet attained the age of 18. Clearly, particularly on clause 3, we've had long debates about mental capacity. It doesn't actually state, the clause as it currently stands, that the person who's over 18 has to have mental capacity. And therefore, my view is you could bring your grandmother with Alzheimer's or dementia along and get them to sign your paperwork, the way this currently states. So my amendment simply seeks to ensure that the person who is your proxy has a mental capacity, Chair, and I beg to move that amendment in my name.
The question is that Amendment 454 to clause 36 stand part of the bill. Minister.
Thank you. As drafted, clause 36 of the bill sets out individuals who are disqualified from acting as a witness or proxy. This amendment would add to that list and exclude anyone from acting as a witness or proxy who would not themselves have capacity to request to end their own life under the bill. This would require there to be an assessment of the capacity of potential witnesses and proxies. There is no corresponding obligation placed on medical practitioners in the bill to assess the capacity of potential witnesses and proxies, and so it is not clear how a person would request and be provided with the required capacity assessment. Thank you, Chair.
Kim Ledbetter.
Thank you, Chair. Chair, it's right that there are some exclusions for witnesses and proxies as set out in the bill, but with regard to Amendment 454, whilst I've got no doubt that the amendment is coming from a good place, it seems both excessive and impractical to conduct a capacity assessment on witnesses and proxies. They are not the patient who is seeking assistance under the Act, and the role they have is a functional one, which will be overseen by the coordinating doctor. The panel can also ask to hear from them if they wish. As such, I cannot support 454.
Mr Francis, do you wish to wind up?
Oh, I absolutely wish to move the motion in my name, Chair.
Amendment 454 to clause 36, as on the order paper. The question is that amendment be made. As many of that opinion say aye? Aye. Contrary, no? No. Division. Lock the doors.
Jack Abbott. No. Lewis Atkinson. No. Juliet Campbell. Aye. Lambos Cheryl Lambos. No. Daniel Francis. Aye. Tom Gordon. No. Sarah Green. No. Rachel Hopkins. No. Sojourn Joseph. Aye. Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Ledbetter.
No.
Pip Morthouse.
No.
Sarah Olney.
Aye.
Dr Simon Ofer.
No.
Rebecca Paul. Aye. Jake Richards.
No.
Sarah Sackman.
No.
Liz Havel Roberts.
No.
Naz Shah.
Aye.
Dr Neil Shafty-Hurst.
No.
Dr Marie Tidwell.
No.
Sean Woodcock.
Aye.
The ayes were 8, the noes were 15, so the noes have it unlocked. We now come to the question that clause 36 stand part of the bill. As many of that opinion say aye? Aye. Contrary, no? Ayes have it. Amendment 164 to clause 37 has already been debated with 144. Ms Savile Roberts, do you wish to move that formally or not?
Again,
withdrawn. Amendment by leave withdrawn. We now come to the question that clause 37 stand part of the bill. Kim Ledbetter? No?
The clause stand part?
Nothing from me, sir.
The question is that clause 37 stand part of the bill. As many of that opinion say aye.
Aye.
Contrary, no. The ayes have it. Clause 38, Ms Saville-Roberts again, are you withdrawing by leave withdrawn? We now come to Amendment 222 to Clause 38, which has already been debated with Amendment 187. Kim Leadbeater to move formally.
Move formally, Chair.
The question is that Amendment 222 to Clause 38, as on the order paper, be made. As many of that opinion say aye.
Aye.
Contrary, no. The ayes have it. So that falls. The question is that clause 38 stand part of the bill. As many of that opinion, Minister? As many of that opinion say aye? Contrary, no? I beg your pardon. Mr. Kruger.
Point of order.
Yes, yes.
I do apologise. In clause 38, did we call Amendment 487 for debate?
It was not moved. 487.
Was it? Did we have the opportunity to move that?
222 was agreed to, so Amendment 487 falls.
Is that so?
My learned friend told me.
Understood. Okay, thank you.
You're forgiven for the confusion. So am I.
Is therefore the opportunity for a debate on Stan Park?
I will permit a debate on Stan. We're talking about 38 Stan Park. Yes. Bear with me. Yes, absolutely. So, the question is that clause 38 stand part of the bill. Mr. Kruger.
I'm very grateful. I don't want to take the committee's time. I would just be invited observation from the sponsor or the minister about the implications of clause 38. It just does read to me extremely broad, the power to make regulation on supplementary, incidental or consequential provision as the Secretary of State considers appropriate for the purposes or in consequence of the provision made by the Act. As ever, not to repeat the point ad nauseam, I am concerned about the degree of discretion given to ministers. So, most of it under the negative procedure. So, I would invite the sponsor or the minister to lay out in as much detail as they're able the purpose of this clause and what sorts of provisions it might enable. Thank you.
Minister?
I thank the honourable gentleman for that invitation. So, my view of clause 38 is that it stands as, if you like, a form of insurance policy, which enables the Secretary of State to respond to the evolving landscape changes that may take place, be it through the implementation period, the issues of data, for example, or substances, or training, or the setting up of the system. And clause 38, as I see it, is ensuring that there is a, if you like, a safety net or a fallback position enabling the government to make changes that might be required. I will be.
Am I correct in thinking, Minister, this is a very standard procedure, but it's actually related to very minor amendments, i.e. consequential, transitional provision, etc. So it wouldn't be for any big changes to the bill, it would just be small amendments, which would be very burdensome to put before Parliament every time such small changes needed to be made.
That is indeed my understanding. This would be about minor changes rather than major fundamental changes to the bill or its provisions.
I'm grateful. As I understand it, so I have seen these clauses in standard legislation before, and generally, as I understand it, they're often put in place where new organisations are being established and where there may be knock-on effects I mean, so for example, organisations decide to call themselves a name that has to be called a particular name, or they change their name from that. It's in the Act. Tends to be those small things where the powers are vested in the minister, effectively to tinker and sandpaper at the end to get the organisational structure correct.
I think that's a good description of it. The wording, I think, is consequential and transitional regulations is the jargon for it, which I think is another way of saying exactly what right honourable gentleman's described to us. I have nothing further to add.
Nothing further, Chair.
The question is that clause 38 stand part of the bill. As many of that opinion say aye?
Aye.
Contrary, no. The ayes have it.